This is Secretary of Defense Frank Carlucci.
Well, the meeting will come to order at this point, and Mr. Secretary, we're certainly glad to have you and our other distinguished witnesses with us this morning. I apologize, we're a little delayed in getting started. I think a number of us have several things going at once this morning. I'm trying to vote in two different conference committees this morning that are both meeting at the same hour of this particular meeting. This hearing, of course, is a continuation of our hearings on proposed legislative language that would change the current law in regard to legislative oversight of intelligence operations and procedures. A very important matter indeed. We've had an exhaustive study of this matter in the committee already. We have had days of public hearings as well as private hearings at which we have heard from Judge Webster, among others, on sensitive matters that might touch upon classified national security information. And we welcome you to the committee today. We're anxious to have your input. The committee seriously wants to write legislation that is as good as possible, that provides the appropriate balance between oversight and accountability under our democratic process, while at the same time protects those matters which, of necessity, must remain guarded, must remain secret, protects the sources and methods which must be used if we're to have an effective national intelligence operation. So we welcome you this morning. We're glad you're here, and we value your insights. Let me call, before we turn to you for your opening statement, to other members of the committee to ask if they might have some opening comments. I'll begin with the Vice Chairman.
Thank you, Mr. Chairman. Secretary Carlucci, welcome. I should point out, for the benefit of those in the audience and those who may be watching, that you are in the process of recovering from a touch of the flu. We'll try and take that into account. That flu bug has touched many of us in the Senate as well. Your time is limited. We appreciate your coming up on such short notice. Your time is limited, and I doubt whether you'll have an opportunity to hear some of the testimony from the witnesses who will follow you. Occasionally we have statements that are presented that, in my mind at least, sort of stand out like shining stars in a galaxy. And one such statement is that of Clifford, who is sitting in the front row, who will be testifying later. Mr. Clifford, I hope you'll accept my apologies for stealing a few of your lines in advance. But your statement struck me late last evening as I was reading it as so pertinent and so well phrased that I thought I might at least quote 2 or 3 paragraphs in addressing the issue. One thing that we have heard over and over during the course of the Iran-Contra hearings, and indeed hearings on this bill, is that the President is the sole spokesman on behalf of the country in terms of our foreign policy, and we don't disagree with that. The President may be the sole spokesman of our foreign policy, but he is not the sole architect, and that's the point that we are trying to make. He is not the sole architect of our foreign policy. And Mr. Clark's statement, he said, in my judgment, the Constitution clearly provides to Congress an important role in foreign policy, and this role includes the process of overseeing covert activities. It is part of the system of checks and balances among the separate branches of government, and we should remember that the oversight process does not give the Congress a veto, only a voice. Another paragraph that struck me last evening: the oversight process could have served a significant salutary purpose in talking about Iran, giving the President the benefit of the wisdom of those who are not beholden to him, but beholden like him directly to the people and prepared to speak frankly to him based on their wide and varied experience. And finally, on page 10 of his statement, the purpose of this legislation is not to assume good faith, but to ensure good government. And I think that really sums up the essence of the legislative bills before us, of proposals to ensure good government, not assume good faith. And Mr. Clifford, I appreciate your statement. We'll talk about it at length when you testify, but I thought, Secretary Carlucci, you should have the benefit at least those words coming from witnesses who will follow you.
Senator Murkowski.
Thank you, Mr. Chairman. I have a statement which we've all entered into the record as read. However, I do want to welcome Mr. Carlucci this morning. I think I would echo the remarks of my colleague from Maine as far as the frustration of this senator and the oversight responsibility, which I feel belongs with a position on the Intelligence Committee, yet knowing that the administration must have flexibility, the President must have flexibility, but the question is what's reasonable, and I have already experienced one instance that I consider unreasonable as a member of this committee. So I would look forward to the testimony that would emanate from the hearing this morning to try and address our ground where we can meet our responsibility, our oversight responsibility, and still protect the strategic interests of our country. I thank you, Mr. Chairman.
Thanks, Senator Murkowski, and we'll enter your full statement into the record. Senator Hecht, any opening comments this morning?
Thank you, Mr. Chairman. Publicly in this room, when we met last time, I stated that I was against all the legislation that's been introduced. I have not changed my mind. I do not see the need for the steamroller effect. You mentioned that we've had exhaustive hearings. We've had a lot of hearings. To say they've been exhaustive, no, I don't think they have been. What we're doing is a further continuation of the Iran-Contra hearings. We are hurting our intelligence worldwide. You know, worldwide intelligence is worldwide cooperation. And who's going to trust us when we have all these cameras in front of us, other countries not knowing what's going to come out, people who've risked their lives to work with us, help us, heads of state, hostile countries, and I don't think we're acting in a manner which the United States Senate should do. I think these hearings, I think we have got to take a lot of time on this. I think we've got to take a lot of time in our secret room in H219, and I would certainly say, hold up, we're going too fast, because let's not destroy our intelligence operations around the world. Thank you.
Thank you, Senator Hecht. We're going to continue in the undecided column on this matter that is pending. Senator Specter, any opening comments that you'd like to make?
Well, I join my colleagues in welcoming you here, Mr. Carlucci. Great pleasure to see you on the job. I regret my late arrival, but I've been attending the hearings for Judge Kennedy on confirmation. We'll be moving back and forth between the two committee hearing rooms. I have heard what my colleague Senator Hecht has said. In the earlier hearings which we have held, I have expressed my own view on the importance to have congressional involvement and congressional oversight, and it seems to me that that is not possible if we are to accept the President's letter to this committee saying that he will give us notice within 48 hours absent extraordinary circumstances. Because if we sit back and accept that, then the position on congressional oversight is weakened substantially from what it was on the Iran-Contra matter, where the statute required timely notice, and we found that some 14 months had elapsed before the Congress found out about the sale of arms to Iran, and then only because of disclosures through collateral sources. So that it seems to me that if there's to be any meaningful congressional oversight, there's going to have to be a fixed requirement for the President to notify the Congress. Beyond the issue of the congressional responsibility in that regard, I further believe that it is very much in the national interest for the President to have the advantage of the institutional wisdom of the congressional leaders. The President obviously has the authority to act as he sees fit without concurrence, but had there been some other considerations and some other people participating, perhaps the views of your predecessor, Secretary Weinberger and Secretary of State Schultz, in opposition to the sale would have been the national policy of the United States, and that would have been much better for the country. I might say, Mr. Chairman, we're still awaiting the responses from the Department of Justice on the constitutional issues. I checked on that a few moments ago and found that they had not responded. We had hearings last week on the constitutional issue, and I would hope that the administration would let us have those materials at an early date so we can give it careful deliberative thought before 3 o'clock. when we weigh their responses to these weighty constitutional issues. Thank you, Mr.
Thank you very
Chairman.
much, Senator Specter. Senator Warner, any opening comments
Thank you,
today?
Mr. Chairman. Mr. Chairman, despite my great respect for you and the Vice Chairman, I have as yet remained uncommitted on this very important issue. I did so largely because I felt, as a courtesy to the witnesses who are going to come forward today, it would be beneficial to approach this with an open mind and then at the conclusion of the testimony formulate my own opinion. We're in a struggle not unlike the one we visit from time to time of the War Powers Act, which has the authority, the executive branch or the legislative branch. And I've consistently come on the side that the executive branch under our Constitution has the primary responsibility for the foreign affairs, the external affairs of this country. Perhaps you might, in the course of your remarks, touch on that, because I think there is some relationship. And as you know, we've had extensive debate on that issue, certainly here in the Senate, in connection with the Persian Gulf. But I will look forward to your testimony. I believe this is your first appearance. Am I not correct, as Secretary of Defense?
Yes, sir.
Well, it is an important one, and I wish you well.
Thank you very much, Senator Warner. I might say that if your position of keeping an open mind, examining all the facts, being careful before you reach a conclusion and trying to legislate on a thoughtful basis, it became a precedent around here that it could dangerously upset the way the institution usually functions. So we have to be a little careful about that. But
well, it's kind of nice to have at least one maverick in the bunch. You're talking about a man who paid the price in the Bork case. You're looking at him,
well, you're looking at another one, Senator Warner. This is a this is a bipartisan hearing this morning. I have Republicans on the right of me and on the left of me today as we sit around the table. But in all seriousness, again, Secretary Carlucci, we do welcome you here on this first occasion of your appearing before this committee as Secretary of Defense. Let me say I take very seriously all the comments that have been made, including those by Senator Hecht as well. This senator believes we must give the President the flexibility to act in emergency situations. A committee of 535 members of Congress cannot deal with sufficient flexibility with emergency situations. The senator also believes that we must, as I said in the beginning, strike the very careful balance between assuring the kind of accountability that will help our country and I think also help our President. It's been said. I'm convinced that had there been a greater sharing of views, including the views of the congressional leadership and the members of the Intelligence Committee with the President before the Iran-Contra matter, that the kind of damage that's been done to this country by the public disclosures that had to take place during that kind of investigation, Senator Hecht said, could have been avoided. So the right kind of process that can avoid damage, can avoid disclosure, can avoid the kinds of actions that make it unsettling for our allies as they seek to cooperate with us on these sensitive matters. And that's really what we're striving for. And I want to assure the members of the committee there'll be no steamrollers. We want to have the best collective judgment out of this committee. We've had several sessions with between our staff and the members of the administration and their staffs just this week, as a matter of fact. We are asking you here sincerely to seek your advice and your best input. And let me express my personal appreciation to you, both during the time that you have been National Security Advisor and now in your new position. You have certainly indicated time and time again your willingness to sit down with this committee, your own commitment to trying to improve the policymaking and the oversight process in a constructive way, and I want to express my appreciation to you for the spirit with which we have always been able to share thoughts, and I think it has been beneficial to the country, and pleased to see you in your current position, and we welcome you this morning.
Thank you, Mr. Chairman. Mr. Chairman, I have a prepared statement, but in view of the shortness of time, with your permission, I will submit it for the record and just lead off with a few informal comments, if I might. Let me say, first off, that I agree thoroughly with the sense of this committee on the importance of congressional oversight. You, in effect, are a surrogate public and you contribute to the great strength of our intelligence institutions. You mentioned that you want to make this legislation as good as possible, and it is in that spirit that I am here. I asked to testify, partly because of the dialogue that we had, but partly in an effort to work with you in strengthening the oversight process. You will recognize that it is rather extraordinary for even a former national security advisor to come up and testify as to events which occurred on his watch, so to speak. Senator Cohen, in introducing this legislation, indicated that it was designed to correct flaws in the system. Yet both the Iran-Contra report and the Tower Commission report indicated that there were no legislative flaws, that the breakdown had been on the people side, so to speak. And when the President asked me to come into the job as National Security Advisor, I did in effect what any incoming CEO would do with a troubled company. We changed a number of the people, we changed the organizational structure, and we changed the procedures. We issued a directive forthwith, on the President's instructions, directing the NSC not to be involved in covert action activities because, in my judgment, that was a conflict of interest. The NSC is the overseer on behalf of the President of the process. We established an Office of General Counsel with full authority to delve into any matters in the NSC and report directly to the Assistant to the President for National Security Affairs. And that office, I might say, is a very busy office and functioning very effectively. In terms of process, we tightened up the management lines, and we issued a number of directives, including directives which impacted on covert action activities. We specified that all findings should be in writing. There should be no retroactive findings. We indicated that the Congress, except in extraordinary circumstances, should be notified within 48 hours. And germane to Senator Specter's point is we indicated that in the event of extraordinary circumstances and the President determined that the delay should be longer than 48 hours, that this delay should be memorialized in writing and should be reevaluated by the NSPG, the NSC in effect, not less frequently than every 10 days. So we established a fail-safe mechanism in the case of any delay in notification. We also agreed to provide to the Congress copies of the findings and the so-called memorandum of notification, which traditionally fits the findings into a foreign policy context. So in our judgment at least, we took substantial corrective action which is sufficient to deal with whatever problems might arise in the future. In terms of the specific legislation, you have, of course, had articulated to you the concerns of the executive branch. Let me only say, from my own experience in the intelligence area, the issue is not an issue of trust between the Congress and the executive branch. There is nothing more debilitating to this dialogue than the finger-pointing on leaks, and I hope we could avoid that. The issue is really perceptions. And if our intelligence assets around the world, particularly cooperating intelligence organizations, perceive that the CIA has no control over the information which is given it, in other words, if the agency is obliged to disgorge whatever the committees may want, if there are no boundary lines, then it is very clear to me, based on my experience, that our intelligence assets will dry up. I am also, from my DOD perspective, troubled by the provisions in the bill that would confuse the lines of authority between the Secretary of Defense and the Director of Central Intelligence by having subordinate entities within departments subject to the regulations of the DCI when they are assisting in covert action activities. If I am to be accountable for my organizations, they have to be included under my regulations. Indeed, one could interpret the legislation to indicate that subordinate organizations would be providing information directly to the Congress. It is obvious from what several of the senators have said that the key issue that you face is the so-called obligatory notification to the Congress, the constitutional issue, if I may put it that way. We've had considerable dialogue on that subject. I am not a constitutional expert. Senator Warner commented on the President's ability to conduct foreign affairs. I can only say that I have served in senior positions under 4 presidents now, and they all felt very strongly about this. The issue of obligatory congressional notification came up time and again in the Carter administration. I think it's fair to say that President Carter felt as strongly about this as does President Reagan, and so did past presidents. Indeed, as I was looking through the material last night, I found that you had a letter from Stan Turner on this subject. On this point, I will, of course, defer to the Department of Justice. I can only tell you that the President feels very strongly on this issue, so strongly, in fact, that I would speculate that should it reach his desk in this form, he may well see fit to disapprove the bill. In summary, let me point to a quote that you yourself made, Mr. Chairman. I think you talked about Congress being the backseat driver, and if we don't want the Congress being the backseat driver, the Congress ought to have a role in planning the trip. I agree with that thoroughly, and as you alluded to, I attempted to work very closely with the members of this committee as we drafted the current NSDD on covert action. And I, by the way, have an unclassified version now of that NSDD. If the committee wishes, that can be submitted for the record. I believe quite firmly that the Congress has the tools for effective oversight. We have a new team in the executive branch dealing with these issues. We have procedures. The existing statutes are in place. I think the problem has been fixed. I would argue that we don't need to fix it again by imposing unnecessary constraints on the President and contributing to what could be a debilitating process in our intelligence organizations. Thank you, Mr. Chairman.
Thank you very much, Mr. Secretary, and your full statement will be entered into the record, and we also appreciate your presenting the unclassified version of the NSDD, and that also will be entered into the record. And I think it does represent some very significant progress that really grew out of a cooperative effort between this committee, yourself and others in the executive branch, and is a very much a positive step in the right direction. Let me ask one brief question before I turn to other members of the committee. You talked about the problem that you had from an administrative point of view of seeing sub-elements of other departments or agencies placed under the DCI administratively. What section of the bill specifically were you referring to there?
I believe it's section 503 A3, where it says each finding shall specify each and every department, agency, or entity of the U.S. government authorized to fund or otherwise participate in such activities, and I'm referring to the word entity, and there are entities, sub-entities in the Department of Defense. And then it goes on to specify that any entity other than CIA directed to participate in any way in a special activity shall be subject either to the policies and regulations of the Central Intelligence Agency or to written policies or regulations adopted by such department, agency, or entity in consultation with the Director of Central Intelligence to govern such participation.
The intent there was not really to put these entities under the control or direction or administrative control of the Director of Central Intelligence, but to make certain that if an intelligence operation were carried out by another agency, and there was a lot of, I think, time and time again, we heard the example, what if the Agriculture Department were asked to carry out a covert operation? Would they then still have the same responsibility to report to the oversight committees of this action, since the current law uses the term intelligence organizations, I believe, shall report, or intelligence activities. And I think that was the intent, rather than trying to literally bring the other departments to make sure that they would comply with the relevant reporting requirements as if they were a normal intelligence agency. But,
well, that may be a drafting problem in terms of the confusion of the lines of command, but you raise a broader issue, of course, and it's far be it from me to get into questions of committee jurisdiction, but we do report in DOD to our own oversight committee, and I would be troubled, certainly, if the definition of covert action in this bill were to apply to Department of Defense activities. For example, a tactical commander in the field may want to engage in a disinformation campaign.
No, I think what we're talking about is activities carried out pursuant to presidential findings of the kind of nature that we've all been dealing with in the past. You simply wouldn't want to evade the responsibility or the operation of law, the requirement to be accountable to Congress by saying, well, that's not, it's not the CIA, so therefore we don't have to report. But I don't think you're really objecting to that, are you? It's really the problem of the administrative, the possibility of a breakdown of the chain of command.
I have some concerns about the administrative lines of command,
yes.
But you have redefined the term special activities in this bill. In fact, for the first time, an effort has been made to make a positive definition of it. I submit that that is an extraordinarily difficult thing to do, yes. And the way it is cast here, the net is so broad that it would catch a lot of activities yes. that I don't think it is your intent to catch.
Yes, I understand what you're saying, and we'll take another careful look at that particular section. I understand there's already been some proposed changes that have been developed in that language in consultation with the administration. We'll look at that very carefully. Senator Cohen.
Thank you, Mr. Chairman. There's something else quite extraordinary today, and that is the declassification of the NSTD. This comes as a surprise, a pleasant one, but a surprise nonetheless, since the committee was unable to even have a copy of the classified version of the NSTD, except to review on the premises and not to retain, so that we could go over it very carefully. And so for the first time to have it declassified before the committee is, again, a surprise, nonetheless welcome, but we have not had a chance to review it. I want to assure my colleague, Mr. Senator Hecht, that nothing will be said during the course of these proceedings that will in any way jeopardize our intelligence agencies or our relationships with other nations. We'll have a former deputy director of the CIA who will talk about the importance of notice to Congress, the importance that it has for maintaining the integrity of the agency itself, and I will assure my colleagues that nothing said here will in any way jeopardize the nature of our agency's integrity. Secretary Carlucci, you indicated in your statement that the Iran-Contra committee found no legislative flaws, simply a breakdown in people, that the administration found no legislative flaws in its system, simply a breakdown in personnel. And I want to commend the President for making those changes in personnel. But if it was only a question of changing personnel, why did the administration feel it had to change its own internal policies and regulations?
It was less a question of changing those policies, Senator Cohen, than it was my feeling in consultation with the President that our people needed clearer guidelines under existing legislation. So what we did in working with the committee is to try and clarify the procedures. I am not arguing that everything was perfect when we came into the NSC. Indeed, as I indicated, as an incoming CEO, I found a troubled company. So I took what I thought were the appropriate measures, but that is a far cry from recommending fundamental changes in statute on the process of legislative oversight. I don't think anybody argued either during the Iran-Contra, in the Iran-Contra report, or during the proceedings of the Tower Committee that the intelligence oversight legislation was flawed.
Well, as I understand what you're saying then, that we had existing procedures within the administration that were adopted pursuant to statutes that have been passed by prior Congresses, and that there was some ambiguity or doubt about the implementation of those procedures, as well as some doubt about the personnel who were carrying them out. So what you did, in effect, was to clarify what you believe the existing statutes and regulations required by saying, number one, we should have no oral findings. So that was a clarification of a rule that should have been applied before.
Correct.
Every finding shall be in writing. That, by the way, is required by this statute, which simply is a clarification of existing law. Number two, there should be no retroactive findings. That, again, is a clarification of prior practice that should have been employed prior to the Iran affair. That also is required by this legislation, so there's no conflict. Number three, the NSC ought not to be involved in operations. Again, that is simply conforming to what everyone thought was the prior policy, or should have been the prior policy, which is what this legislation does. So
covert action operations. The word operations in a broad sense.
Covert activity.
Covert activity.
Right. So in essence, what you did was clarify existing law and procedures, and in essence, what we have done in this law is to do exactly the same thing, precisely the same thing on those key elements. So there's no conflict in terms of what you seek to do and what we seek to do. We are, in fact, on the same parallel track. Now, one thing that I think is perhaps, well, let me go back here a moment. You made the statement that if there is no control over information given to Congress, then we're going to lose credibility with our allies. I would agree. But are you suggesting that there has been no control to date over information given to Congress?
No. What I'm referring to is the provision in Section 502 that obliges a Director of Central Intelligence to give you whatever information you request. There have traditionally been well understood boundaries. For example, sources and methods, very important. Internal executive branch deliberations. There you get into issues of executive
There is no claim under this legislation that executive privilege does not apply to those areas not required by existing law.
Well, I consulted with my lawyers just prior to this hearing, and they indicated that they see some conflict there, so I suggested that is an area that we need to straighten out.
Let me straighten it out if I can right now. There's a question about sources and methods. I think I indicated in the day that I testified before the committee that I was quite prepared to amend the proposal to take into account the legitimate concerns of the administration. Would you have any objection to language such as the Intelligence Committee should be appropriately informed of participation of any government agencies, private parties, or other countries involved in assisting with special activities?
I don't have a real problem with other government agencies if the word substantial is used, because you might want to go out and borrow a screwdriver from some agency or something like that. I have some problem with other governments, having worked with other governments in the intelligence
do you have a problem with that language that's used there?
The other governments are just extraordinarily sensitive on this point. I think you've already had testimony before you on the Canadian Embassy rescue operation, where the Canadians indicated that if the Congress was to be informed, they wouldn't cooperate.
I guess what I'm at, are you troubled by that language?
I'm troubled by other governments, yes, but I'm not equipped to get into wordsmithing here in this hearing. I'd prefer to have...
I don't want to take advantage of this situation, realizing that you're in a new position with different responsibilities, but the reason I quoted that language is the language that President Reagan drafted and sending a letter to Chairman Boren and myself. It's contained in section 4 of a letter that he sent to us, and the date of the letter, I'll get it precisely here, is, well, undated on top of the letter, but a letter to Senator Boren. And that's paragraph 4. The Intelligence Committee should be appropriately informed of participation of any government agencies, private parties, or other countries involved in assisting with special activities. So the reason I'm asking the question, if it's okay with the President, and he's assured Chairman Boren and myself that this is...
let me give you a little background on that, because we did not, at least I was not aware of this in the NSC when we were drafting the regulations, and this was included over the objections of a number of people, including some people in the CIA, as it applied to foreign governments, only when we discovered that Director Casey had made that kind of an agreement already with the committee. Your question to me was, am I troubled by it? Yes, we are simply fulfilling an agreement that Director Casey
Well, this was long after Director Casey. This is from the President. Came
no, I understand. But he was the first one to agree to that.
Well, all right. But the point is that the President, as recently as several months ago, reaffirmed that this would be part of his policy.
We will live with that. You asked me if I was troubled. I am troubled.
Well, you will live with that. And if I were to include that in the legislation itself, I assume if it's all right for the President to declare this in a public letter to Chairman Boren and myself, then the administration will live with that language.
All right.
All right. You also indicated on actually what it comes down to is really the obligatory notification to Congress. That is the major point of contention in this legislation. I think all of the other points we can work out and have tried to take into account administration, either clarifications, improvements, and we spent the last 2 days doing that. I think we've achieved that. The basic problem comes down to the obligatory notification to Congress itself. One thing that you've indicated, and I might point out to my colleague, Senator Hecht, when Mr. Gates was being considered for the nominee for the directorship, I recall him testifying that he could not conceive of a situation in which notice should not be given to Congress within 48 hours or 2 days after the initiation of such covert activity. Director Webster, during his confirmation proceedings, reiterated the same thing. We are going to have John McMahon, from the former deputy director of the CIA, also indicate that Congress ought to be notified within that time frame. These gentlemen, with their vast experience, have not found an example in their cumulative experience in which notice to the Congress of a covert activities has jeopardized those activities. Indeed, I think the testimony will be just the opposite. It will strengthen the agency rather than undermine it. And I'm curious as to why the administration is so adamant in opposition to simply notifying 8 members of Congress, the leadership of the United States Congress, of a covert activity being carried out to further a foreign policy.
Well, as you're aware, Senator Cohen, I too served in the CIA, and I can't cite you a past example where indefinite deferral of notification would have been necessary, although I can cite you 2 examples where the Congress was not notified in advance, and I think justifiable examples.
But can you cite me one example where it would have jeopardized lives?
One can speculate, but I don't think that's the point. The point here is that this is a fundamental separation of powers issue. I indicated in my opening remarks that I was really not the best person to address that issue because it's a constitutional issue. This isn't a question for the director or the deputy director of the CIA. This is a question for presidents. And presidents feel very strongly about their constitutional responsibility to conduct foreign policy.
Let me come back to the point then. Do you subscribe to the notion that a president could take action that would be inconsistent with an existing policy or even law, declare it to be a covert activity, and then withhold notice to the Congress for a period of 10 months, 14 months, or longer?
No, I think the president is charged.
In his sole discretion, he has that power? Is that?
The president is charged with faithfully executing the laws of the nation, so no, he would not do anything in violation of law.
Not violation. The testimony during the Iran-Contra affair was by the Department of Justice that even though there were an existing law on the books, the president could circumvent or disregard that particular provision by declaring it to be covert activity and have different powers under a covert action as opposed to a public policy. And if that's the case, you could have, for example, a prohibition, a statutory prohibition against transferring weapons to, let's say, Iran or any other terrorist sponsoring country, and yet the president wants to open up a new relationship with Iran, therefore declares a policy to be, an action to be covert, and then undertakes that covert activity without notification to Congress for as long as he determines it's in the best interest of the country. Is that what the view that you subscribe to?
I take it you're also referring to the section in the draft legislation 503A5. A finding may not authorize any action that would be inconsistent with or contrary to any statute of the United States. This business of attempting to close every conceivable loophole that a president might find under some yet to be defined circumstances can also result in some damage to our foreign policy equities. Once again, I'm not a lawyer, but as I read this provision, if we are shipping arms under a covert action finding, that may be inconsistent with the Arms Control, the Arms Export Control Act. So which law governs? So I think this particular provision would set up some conflict there. Obviously, I'm not going to be put in a position of saying presidents ought to disobey the law, and it's a question of what you're dealing with is a question of constitutional responsibilities versus statutory responsibilities, and as we say in the Pentagon, that's over my pay grade.
One final point. With respect to the notice under the NSDD, the point being with NSDD directives, they can be changed, disregarded at the discretion of the President any time, with or without notification to Congress, I assume. And that's one of the reasons why we want to put it in statutory language. But secondly, you point out in the NSDD that we have a provision which would require a reevaluation of a covert activity under which notice has not been given to the Congress every 10 days. Right. Now, theoretically, that means that a president could defer notification for weeks or months or possibly even longer than a year simply by reviewing it every 10 days.
Well, that is correct, although it says NSPG, which means that it's quite a painful process. The president would have to convene an NSPG every 10 days and go over this, and hear from his advisors. You cited the example of 2 advisors who objected to the arms control or the arms sale to Iran. You'd have to hear from those advisors every 10 days, and that might be quite an enervating process. So if that's a loophole you're trying to close, I think this does the job.
Thank you.
Thank you, Senator Cohen. Senator Murkowski, question?
Thank you, Mr. Chairman. Mr. Carlucci, it would appear that we're in a situation where you've voiced your opposition to the bill with regard to the lack of flexibility or the ability under extraordinary circumstances to have an alternative, which quite clearly this legislation addresses 48 hours as mandatory. I don't know whether there's any common ground of an area for a compromise or an alternative. I would think that if we had the time, Mr. Chairman, to go down through each of our mutual concerns, why perhaps they could be adequately addressed. For example, you said you oppose the 48-hour provision in the bill because you fear that other countries will hesitate to cooperate with us, fearing disclosure to the Congress. But my concern in that example is the credibility of just that. Indeed, wouldn't the other countries have to assume that their cooperation with the United States would be disclosed to the intelligence committees, because that's a policy of our country. So if they start internally second-guessing, recognizing we have a mandatory oversight responsibility, I just question whether that kind of a concern is a legitimate concern, recognizing the obligation we have.
Senator Murkowski, I don't know how many times when I was in the CIA cooperating intelligence organizations expressed their concern on this subject. Certainly it was numerous. They will frequently tell you that, well, we will give you this information providing it does not go to your Congress. Now, that may be unfortunate, and that's not the way we look at things, but it is the way they look at things. So we're dealing, in this case, perception becomes reality, and if we are interested in maximum intelligence effectiveness, we have to take this into consideration.
Well, one would draw the conclusion that the Congress would be considered less trustworthy in keeping a secret than the executive branch. And one, that isn't the case, but obviously that leaves us with no other
I'm not
alternative.
making that argument.
I know you're not, but that's a conclusion one has to come to as a consequence of where we are. You know, we've had an experience, and it was an unpleasant experience, not only for this committee, but for the administration. And as a consequence, if we'd have had notice in a reasonable manner, things may have been different, but that's hindsight. We'll never know. What we're trying to do is in a responsible way, look at appropriate legislation so that the risk is lessened. Now, you know, we don't want to leave a loophole that can be abused. And this senator is not necessarily wedded to you know, this absolute language, but to suggest that there be this broad area where the extraordinary circumstances, as judged by the President and his immediate advisors, isn't subject to some reasonable oversight, you know, it just leaves us at an impasse. We've got a policy void here, and I appreciate, you know, what you have to do. The President's elected. He's held responsible. His people are held responsible to him. But it would seem to me that if you could come up with some constructive suggestions on how we can maintain an oversight responsibility within a reasonable framework that doesn't allow for an abuse or a loophole.
I agree with that formulation, but that once again begs the constitutional question. We can certainly agree on process, procedures, on the boundary lines of providing information, but presidents, and not just this president, feel very strongly about their constitutional prerogatives, and therefore they are inclined, as was President Carter when I was in the CIA, to insist on that right to withhold information if necessary. And that may be unfortunate. You view it as damaging to the oversight process. They view anything else as damaging to their ability to conduct foreign policy. And I'm not equipped to suggest to you in this hearing a compromise on that fundamental constitutional issue.
Well, I understand that, and you understand the concern that this senator has, because we did see an abuse, and it was unfortunate, and had we, that's the whole purpose of this exercise, as we're all aware. And you know, if the administration is just going to say no, then we are at constitutional loggerheads, and I assume that it'll be a full employment act for the attorneys, like a good deal of other activities around here.
Very similar to the war powers debate, if I may say so. I don't want to get into that.
It is, but you know, it just leaves us at both ends of the spectrum, and you know, that's unfortunate. I'm not looking to change, you know, major policy or looking to change the flexibility of the President or his responsibilities, but I'm not satisfied with the system now because, frankly, it was abused badly. And it wasn't a question of leaks. It was simply a question where we had no knowledge until after the fact. I've sat on this committee, Mr. Carlucci, and felt that if I didn't ask the question just absolutely correctly, I wouldn't get the information. And, you know, that's not appropriate, but that happens. And we, you know, that isn't the President's wish that that set of circumstances come out, but it's a function of the process of covert activities.
No, let me argue with that point.
All
I
right.
do not think it is a function of the process of covert activity. And that's the very point I was trying to make in my testimony and in my extemporaneous remarks. Our reading of the Iran-Contra report and of the Tower Commission is that it was a breakdown of people, atmosphere, the kind of hothouse atmosphere that existed, the overemphasis on secrecy. What I am arguing before this committee is that all of that has changed. We've created a new atmosphere of cooperation with the Congress and the NSC. We've created a new set of procedures. We've brought in a new set of people, new leadership in the institutions. And there are some problems that do not lend themselves to legislative solutions. They lend themselves better to people and process solutions, and I would argue that this is one of those.
Just one more quick. Well, I commend you for instituting new policies and new procedures, which were obviously necessary as a consequence of the fact the system wasn't working correctly. The system was there. So you've seen corrective action, as I think the senator from Maine indicated. That's the effort here to initiate corrective action, and if there is not a middle ground, why obviously we know where we're going. We're going to the Supreme Court for a ruling on it, and maybe that's it. I don't know. I think the dialogue has been helpful to me because I do understand and appreciate your concern. You know, one can conclude as well that the report that came out of the Iran-Contra hearing urged changes such as are proposed in this legislation as well, but that's neither here nor there. That's just one of those things we live with.
Several ways, I guess.
There's several ways of looking at it. I have no further questions, but I think the senator from Maine
Did you want to make one additional point here?
Secretary Carlucci, you indicated there has been a change in personnel and a change in procedures, and indeed there have, but those can change again. We have another election coming up, perhaps a different party taking power, hopefully not from our perspective, but that man, you may no longer be there next year. And so we have no guarantee in terms of the continuity of those procedures, personnel, atmosphere, environment, hothouse or cold house. And that is the reason why, if the changes that we are making are in fact quite consistent with the exception of the notice, the 48-hour notice, then it seems to me that this is an appropriate thing for us to pursue to make sure that we try to maintain that same line of propriety that you are seeking to do.
I would only argue that we need to be very careful about the boundary between necessary legislative action and appropriate administrative action. We have to allow our presidents to administer.
The basic difference between your testimony and what is being set up here is the question of timely notice. Whether or not Congress, under the constitutional scheme of things, is entitled to have timely notification of a covert activity which has been initiated by the President of the United States without prior notice. And what you're saying is that under your definition or that of the Department of Justice, timely notice, in essence, is whatever the President says it is.
Well, I'll defer to the Department of Justice, but that's not my reading of that. The word timely does have meaning. And
under the Department of Justice, they've indicated the President has the sole discretion to decide what is timely.
And the President feels very strongly on that point.
So do we.
Senator Hecht.
Thank you, Mr. Chairman. To answer my distinguished colleague from Maine, I certainly disagree with you. I think just having this hearing jeopardizes our intelligence gathering capabilities around the world, just as I think that we were hurt in a terrible manner by the Iran-Contra publicized hearings. And so we have a basic...
was initiated by the administration. That's what hurt this country.
Well, we have a basic disagreement, and so as Bob Dole would say very, very eloquently, one of us is wrong. And so we'll go on from there on that. I think also we got a responsibility in Congress. Now, we're talking about the executive branch talking to us. You know, let's look back 2 years ago in this committee. In my opinion, it leaked like a sieve in plain language. There was constant oratory on the morning TV and in the press. I think that we have to take more responsible position. I remember during that time, I had many conversations with the late Bill Casey, and I said, you know, you have to be very careful. And we do have leaks. Now, Mr. Carlucci, you were in the CIA, you said. Is it not true that you were polygraphed at time to time?
I was what?
Polygraphed?
Oh, yes. At least twice. I volunteered to take a polygraph.
Are you aware that the staff of the Intelligence Committee is not polygraphed?
I'm aware that polygraphs are not used up here, yes, sir.
And, but
Where the Secretary of State has not been polygraphed and refuses to be polygraphed?
I am definitely aware of that, but I don't see how that has relevance to the staff of the Intelligence Committee. And I never have found that, and I'm not advocating every senator has to be polygraphed, but I certainly think the staff should be polygraphed. Let's get back again to some other questions in this. We have not really defined what is covert, and I do not want to right now, and what is clandestine operations, because one can lead to another. But we have to be very, very careful, because in reality, they are very, very close, and this is the type of situation. We're not like the Second World War, where we had the luxury of several years to build a military force. We have to react on a dime, to use an expression. If you have to make a spontaneous action, Secretary of Defense, along with the President, and we're out of session, and you have to move, and people might not be around, is there any way possible you could round up 8 people and come up with a decision when you thought the security of America was threatened?
Oh, I think there are examples. It depends on how the legislation is worded, of course, Senator Hecht, whether it's a good faith effort or whether it's an absolute requirement, but there are certainly examples of our being unable to locate members of Congress in circumstances of emergency. When the Congress is not in session, there is a good amount of travel. And I myself have experienced frustrations. I know the President has talked about frustrations in locating members of Congress. So it is a practical problem, yes.
Well, it's the security of the country at some time could be threatened, and obviously our enemies would understand when Congress is out of session, it's difficult to get a decision. Wouldn't that send out the wrong message?
Yes, I think it does. If we are viewed as indecisive, that's one of the problems that Senator Warner and I have discussed along with Senator Boren with the War Powers Act. It creates an atmosphere of indecision, and that badly damages us around the world. Damages us around the world.
Yes.
Thank you very much.
Thank you, Senator Hecht. I would want to interject here, and I think Senator Hecht would agree with this. I think he has supported strongly the new procedures we put in place in this committee in terms of safeguarding of classified documents and notes which can't leave our space, and the removal of members, the support of the joint leadership if any leaks occur. And I think he would agree with me. Judge Webster has indicated to this committee that since these new rules have been in place, there have been absolutely no leaks out of this committee, and it's a responsibility I think the current membership of this committee takes very, very seriously.
I certainly congratulate you on that, but in reference to what distinguished Senator Maine said, next election, who's going to be here, and I think we should make safeguards from right on out, and I think that we have not done that, and I think certainly the polygraphing of the staff would send a message in the right direction.
Senator Warner.
No, I yield to the Vice Chairman.
One point. In terms of locating 8 members of Congress, my understanding is that the Reagan administration, with the exception of Iran-Contra, has never had a difficulty and never encountered any difficulty in locating the chairman and vice chairman of the intelligence committees in the House, the Senate, or the leadership if necessary. There was only one occasion in which notice was not given. That happened to be the Iran affair. But prior to that time, with a possible exception of the mining of the harbors, my understanding was this administration has found it very easy on each and every occasion to notify members of Congress who had the need to know about covert activity.
If my memory serves me correctly, the difficulties that I was referring to go back to the Carter administration. Right. I think there was an instance in which they had difficulty locating people.
On that particular subject, as both the chairman are aware, we have had a little problem internally within our committee as well, as far as notification in a timely manner
the members, and that's an internal matter that I think we've addressed, but I want to make sure that everybody understands the problem's just not one way. It can work internally as well.
Mr. Chairman, first I want to indicate clearly that I support the chairman and the vice chairman in bringing this issue to the formulation of a bill and having a hearing to focus on it. I think those were proper and judicious steps in light of the seriousness of this question. But I turn now to the 48-hour rule, which is the area that concerns me the greatest. And you, in concluding a response to Mr. Hecht, touched on the allied or friendly nation participation. Hypothetically, if we had such a rule, how does that impact on the likelihood of other nations associating with the United States in the performance of a covert action?
Adversely. And I think you need to bear in mind, reflecting on what Senator Murkowski said, that these countries just have to understand our institutions. That you are dealing with countries, by and large, in the intelligence world that don't always understand our institutions, that have very different institutions of their own, and simply cannot appreciate the importance of the oversight mechanism and the cooperation between Congress and the executive branch, and are basically mistrustful of the dissemination of information beyond the executive branch. Now, I can't tell you how much cooperation will be lost, because we never know. All I can do is cite concerns that have on occasion been expressed to me, both in my intelligence hat and subsequently, that you people in the U.S. government cannot keep a secret. That applies to the executive branch as well, by the way, but we have a great deal of problem with that. And if you're going to let our participation be known to the Congress, we don't think we can cooperate. That happens.
Without going through the whole litany of other nations, actually there's no parallel to my knowledge with a major Western nation in terms of this sharing between the executive, so to speak, and their legislative, the corresponding entities.
Senator Warner, I'm not an expert. I can't think of an exact parallel. I think Canada and the UK have evolved more in that direction, but I don't think they're
they haven't gone as far as...
No, not...
This is a question you may not be able to answer now, but I would hope you'd provide for the record an answer. As I read through Section 502 of the bill, the Cohen bill, and that's on collection of intelligence, and 503 on the covert operations, I'd like to have you provide for the record that it is your judgment as Secretary of Defense that your department would be completely embraced within this legislation and its definitions, and there's just no chance, other than a willful violation, should this or something like it become law, of any small group somewhere in the world operating perhaps with the best of intentions along a border, should we say, with a hostile nation, of conducting any activity without your knowledge, and in turn you're fulfilling the responsibility to advise the President and the executive branch. I'm just concerned that we can't get into the details, but there have been some operations in the Department of Defense.
Oh, yes.
Of past and recent.
Oh, yes.
Which, in the judgment of this senator, bordered on what we're talking about here. I can't get into the details, and that troubles me greatly.
Let me tell you what I did in that case. I think you're referring to some things that went on when I was Deputy Secretary.
Yes, that's
and
correct.
I had the experience in the CIA, and I set up procedures in the Pentagon that were very similar to the procedures that exist in the CIA, and in fact invited the CIA to take a look at them. And I think those are now functioning satisfactorily, although I've not had time in the short period I've been in office to re-examine that issue. But I think there are now adequate controls in place in DOD.
Let me just complete, because the leadership of this committee and Senator Nunn, the chairman of the Armed Services, and myself as ranking, the four of us are looking at this situation. I just want your assurance, having gone back at your own time to read 502 and 3, if a piece of legislation evolves along this line, I want to make darn sure that it puts a blanket over everything in the Department of Defense.
Well, I am troubled by that. And let me be clear here on the record. This broad definition of covert action and the application to the Department of Defense could result in some circumstances where tactical commanders could not make decisions without coming all the way back up through the system. It could result in confusion between committee jurisdictions. You're on the Armed Services Committee. We report to the Armed Services Committee. So before you get into the business of regulating what might be defined, and is not currently defined as, but what might be defined as covert action activities in the Department of Defense, I suggest to you that you go through a whole other hearing process, because it's a very complicated subject.
Well, now, Mr. Chairman, that brings me to something that's of great concern to this senator, because we've drawn this thus far very carefully to apply to all agencies and departments of the federal government. I'm sure you've had an opportunity to glance through this.
I think it's a definitional problem, Senator Warren.
All right, but we ought to clear it. If we put something into law, it should be written properly. And now is the chance to get it corrected. So would you undertake to work your staff? Go ahead.
Senator Warner, we've been working with the executive branch even this week, and it's my understanding that when we get into the definitions here of covert operations and activities, we have returned to now, or informally agreed to use as the basis of our markup, a return to the executive order definition.
That's
of that
fine.
term.
All right. Then that clears up that problem.
Because some of the copies we have up here this
Yes, that's not reflected yet. That's really been a matter of informal negotiations with the administration.
Well,
and
I've made my point, and you give me the assurance, and the Secretary likewise, that gap's been closed. Mr. Cohen.
To Senator Warner, but I know he has to leave. With reference to the identification of third countries, I don't think the Congress of the United States ever wants to find itself in a position in the future that country 1, 2, 3, 4, or 5, or 9 is participating in a covert activity, supplying $15, $20, or $30 million to carry out that covert action, and no notice of that participation ever being given to members of Congress, who would then be at least shielded from that knowledge, not knowing whether implied or express promises have been made to that country in exchange for its activity. That was the reason for it. That's the first point. I think we are entitled to that kind of knowledge. Number two, you were not here earlier when I read a letter from President Reagan to Chairman Boren, and that letter contained a paragraph that said the following: the Intelligence Committee should be appropriately informed of participation of any government agencies, private parties, or other countries involved in assisting special activities. So we were simply seeking to put into legislation what the President had agreed should be the policy of this administration, I would assume any administration. But third point is that I am prepared to work out a formula whereby it can be achieved without causing the kind of disruption that Secretary Carlucci has at least alluded to.
perhaps not in statutory language.
Well, I think we're gravitating towards a common result here. My question was more along the lines, if we decided that the United States to do a covert action in a country, and we simply needed some of their basic intelligence to fulfill that in a more efficient and effective way, there may be some reluctance to share. Wasn't that the point that you and I were...
That's the point I'm making. You can certainly do what you suggested, but you pay a price for it. And I think we have to recognize that.
Can you think of scenarios by which it would just not be in the best interest of the United States for a president to inform a Congress in this... Beg pardon?
8 members of Congress.
That's correct. Eight members of the Congress.
Yes,
I can think of some
where human lives are at stake. Yes, I can.
Well, that's a broad range. But supposing, for example, a nuclear weapon were stolen somewhere in the world, and it was incumbent on the President to have a covert operation to go in and try and recover that weapon. Now, that's the sort of thing that we created the Nuclear Risk Reduction Center, which is now being implemented. Those are the types of scenarios that concerned many of us at the time we fostered that idea. And this is a category which concerns me a great deal.
Well, that is one category.
The loss of life seems to me is inherent in so much of this business. It's quite general, and it might not provide a standard.
I understand that you have had an exchange earlier on the Canadian Embassy rescue operation, but I think that's a good case. Now, we did inform after the fact, but it's conceivable that that undertaking could have dragged on for a considerable period of time. And I think the President needs to have the authority to withhold information. I gather Senator Rudman said he would have made a different decision. Well, I was one of the decision makers, and I would not have in retrospect, because I think those people would still be there had we not agreed to withhold that information.
Could I follow that up, Mr. Secretary? What would be the situation where a country, be it Canada or someone else, after having carried out such a covert activity, then comes to the President and says, Mr. President, please do not disclose our participation in the role of extricating these hostages because it will undermine our ability to operate in that region of the world in the future, and we are begging you not to disclose our activity. Under those circumstances, could the President, under the definition of timely notice, say, we are not going to disclose this because it's going to involve lives in the future as well as those in the past? It might undercut the ability of that country to function?
Well, those are the kinds of excruciating choices that we elect and pay our presidents to make. He's got 6 lives in the balance. He's got an oversight consideration to weigh against those 6 lives, and he has a friendly country that says, if you inform the Congress at any time, you cannot rescue these people. Now, I don't think you and I, and certainly not 535 members, can sit back and second-guess a president on that.
If we allow other countries to start dictating what our constitutional process is going to be, and we have a major difference on that, but it seems to me we're starting down a very dangerous road where other countries say, you cannot tell Congress, if you do, we won't help you. And if we accede to that, I think we're making a very
they're not
bad
dictating
mistake.
our constitutional process.
In
They
essence,
have every right to tell us that they're not going to cooperate with us in a rescue operation out of their own embassy unless we do it under certain circumstances, and that isn't
sure, they have
tampering
every right
with
to
our
do
constitutional
They have
process.
every right to do it.
Senator Warner.
Mr. Chairman, one further question. I understand our witness does have to return to the White House for a meeting with the President, but your opinion on the Inspector General. Now, we've sort of government-wide formed a pattern, but there's reluctance to have the Central Intelligence Agency conform to the otherwise government-wide pattern. What's the grounds, in your opinion, for an exception?
Well, I think Director Webster has already testified on this, and I haven't acquainted myself thoroughly with that subject, but I would go back to the creation of the Inspector General's office in the Department of Defense, where I did testify a number of years ago. And I think we argue very strongly that national security entities are really sui generis here, that you have a situation where the ultimate person who is accountable, in this case the DCI, may have to order that information be withheld in the interest of protecting human lives, overriding national security concerns, whether it's your nuclear example or some other. And he, therefore, has to have the Inspector General under authority, under his or her authority, in case those circumstances arise. So you can't have unfettered reporting lines between an Inspector General and the Congress in those kinds of organizations.
That's clear enough. Thank you very much, Senator Warner.
Senator from Maine. I don't remember too much business law, but one word I do remember is intent. Is it your intent to stop us from working with third world countries on different operations?
Senator Hecht, there is no intent to stop us from operating anywhere in the world. The intent is to require any administration, this administration or any future administration, to provide timely notice, meaning within 48 hours at the initiation of a covert activity period. That's the intent.
But you mentioned about third world countries. You do not want to have money used by third world. What was that you just mentioned a few minutes ago?
What I made a reference to was the fact that other countries may be participating in carrying out covert activity, contributing either personnel, manpower, or substantial amounts of money to carrying out a particular policy which is undisclosed to the Congress of the United States. And that, to me, is not a policy to be enshrined with in future practice. It ought to be at least disclosed to the committees that a country is, in fact, participating.
The chair hesitates to ever try to impose an order on the committee and or to constrain the discussion here, but I know Mr. Carlucci has to leave just momentarily. We have other witnesses, 3 other witnesses that have generously shared their time, so we do need to move on. Let me ask one last question. Let me say to you again, Secretary, we really appreciate your coming. I think we've made very significant improvements at both ends of Pennsylvania Avenue on the process of oversight and the process of policy making, and I think, frankly, and when people ask me what I think we're doing most importantly in the Intelligence Committee, I talk about the fact that we've made oversight more systematic. I think and that's what Congress doesn't always do too well. We legislate. A lot of the focus, the news media focuses on what legislation have you passed. But in this area, the greatest contribution that we can make, I think, is to have systematic oversight. We can have all the oversight rules on the books in the world, and if we conduct our own oversight in a hit-or-miss fashion, it doesn't work. And I think the fact that both in the National Security Council and in this committee, we've set up a comprehensive, regular, quarterly review of all findings and covert actions in force, that we have at both ends systematically and carefully examined the budget and the use of funds for these projects. It's the systematic process which we're trying to do in a very orderly fashion, I think, that has greatly increased accountability in the process. And that's something that we've worked on together. We've developed parallel structures between the National Security Council and this committee. I think that's very helpful. I do want to ask you this. Let us suppose, setting aside for a moment the differences between this bill and the NSDD, which you've given us an unclassified version. I asked Mr. Cooper, did the Justice Department have any inherent objection to legislation in this area? And he said, not inherent opposition to legislation. If we, let's take the hypothetical, because we do have a concern that we might have a good process, agreed upon process. I do think the NSDD goes a long way in the right direction, but the next president might totally change it, might decide to throw it out the window. We might again have different kinds of personnel involved, and Senator Murkowski said earlier he had to, and I think he was referring to the past, be concerned about asking the right question. Let me say with Judge Webster, with yourself, with our relationship with General Powell, with Deputy Director Gates and others who come before this committee during the time that this senator has been chairman, I feel we've had a very candid situation. We haven't had to worry about asking the right question. We've kept confidential those things that had to be kept confidential, and we've developed, I think, an unusually high degree of candor in the two-way conversation. It's been very good. But if we were to, let us say, if we were to take the formulation of the NSDD and to legislate that, in essence, in place of the current law, how would you feel about that? I ask you that just as a hypothetical.
Well, as you read through the NSDD, you will find that it is very detailed, and including specifying which interagency groups will work on which problem.
Well, of course, you wouldn't go into that kind of detail.
So it gets into internal management processes. As I said earlier, somewhere we've got to draw the line between oversight legislation and internal management. With regard to the concern that you expressed about future presidents throwing the NSDD out, you always have the option of passing legislation at that time enshrining the NSDD, and I'd be glad to come up and testify on behalf of that legislation.
How would we know if they threw it out?
An arrangement has been set up where the oversight committees can be briefed on...
Can be?
Well, they are being briefed.
I'm convinced we are now, but again...
Well, but, Senator Cohen, I mean, if you are saying that you have to have absolute and total unrestricted knowledge into every president's internal management processes, that is just an impossible.
Secretary, no one on this committee is asking for that. And as a matter of fact, I didn't even ask for the NSDD to be declassified. That's something the administration did, unbeknownst to me, today. And so when I was sort of amused at Senator Boren is saying, would you have any objection that we use this document as part of the statute? He said, well, that gets into internal factors. Well, I didn't ask you to declassify that. We've kept that confidential, our access to it. And I don't think it helps to say that we want total access to the inner workings of the administration. We don't want that at all. What we simply want to know is when a covert activity is initiated, we'd like to know about it within a timely time frame. And that means 48 hours as far as we're concerned, and that really is the matter of constitutional debate, which you yourself, I think, indicated. Even though Senator Hecht, you said you didn't recall some of the legal terms, he's not even a lawyer, and he used the phrase sui generis, and you caught my attention with that, Mr. Secretary.
He's been around you lawyers more than I have. That's the difference.
Thank you very much, Mr. Secretary, for being with us and for taking your time. The chair.
We will continue our coverage of this hearing in just a few minutes.
You're watching C-SPAN, America's network. C-SPAN is a non-profit cooperative created and supported by the cable television industry as a public service for its national cable television audience. In addition, C-SPAN is underwritten in part by the following.
Tomorrow's artist. She's very much on our minds today as we make new discoveries in the technologies of sound and sight. We're DuPont, a pioneer in imaging systems and electronic components dedicated to the discovery of better things for better living.
The Bell Companies of Ameritech and its other communications-related companies, leaders in advanced technology, have helped make this programming possible. Ameritech, helping you communicate. The Gannett Foundation, supporting innovative problem-solving in communities and communications, including programs to fund journalism education, community improvement, adult literacy, and volunteerism nationwide.
Join C-SPAN for coverage of the 6th Annual Presidential Conference sponsored by Hofstra University in New York. The conference is entitled Richard Nixon, a retrospective of his presidency. Our coverage will be telecast the week of December 28th during our Event of the Day time slot. We'll feature seminars with John Ehrlichman, Elizabeth Holtzman, and the Honorable Alexander Belonogoff. Monday through Friday, December 28th through January 1st at 8 o'clock p.m. Eastern, 5 o'clock p.m. Pacific Time on C-SPAN.
Keep in touch with C-SPAN through the election year with the C-SPAN 1988 calendar. It will help you follow us throughout the year from President Reagan's final State of the Union address to the inauguration of the next president. Each month, this full-color calendar highlights important election events, such as each state's primary or caucus, and the national party conventions. It also announces many of C-SPAN's programming plans for 1988, public policy events that C-SPAN may cover, and historic dates marking milestones in C-SPAN's history. The C-SPAN 1988 calendar also has plenty of room for you to highlight those important dates of your own. The C-SPAN 1988 calendar is only $4.95. Order yours today. Send a check or money order to C-SPAN Calendar Offer, 444 North Capitol Street, Northwest, Suite 412, Washington, D.C. 20001.
From Washington, this is C-SPAN. We pause briefly now to update our program schedule and to welcome some new viewers to C-SPAN. America's Network can now be seen in Hillsborough County, Florida, on Channel 23 of the Paragon Communications System, managed by Bill Geppert. We're happy to welcome you to our network. Turning now to our upcoming program schedule, at 4 a.m. Eastern Time, that's 1 Pacific, we air a hearing on the presidential elections in Korea, held by the House Foreign Affairs Subcommittee on Asian and Pacific Affairs. Then at 5:15 a.m. Eastern Time, the topic shifts to pending legislation dealing with the nation's airports and airways. The featured speaker at the National Press Club, Patricia Hahn, a staff member with the Senate Commerce Aviation Subcommittee. At 5:45 a.m. Eastern Time, we re-air Sunday's debate in the U.S. House of Representatives on a short-term budget resolution, funding government operations for 1 day. Our Process and Policy Viewer call-in program re-airs at 6:25 a.m. Eastern Time. That's 3:25 on the West Coast. This week we focused on Congress as an institution and looked at how it has changed over the years. At 8 a.m. Eastern Time, that's 5 Pacific, we open our phone lines for discussion of the news making the headlines over the weekend. Joining us to take your questions and comments, Peter Pritchard, managing editor for Cover Stories at USA Today, and syndicated columnist Georgianne Geyer. Monday at 9:30 a.m. in the East, that's 6:30 in the Pacific time zone, we bring you a hearing on student loan defaults held by the Senate Labor and Human Resources Subcommittee on Education, Arts, and Humanities. That panel is chaired by Claiborne Pell of Rhode Island. The House of Representatives meets Monday at noon Eastern Time. Members are expected to take up budget legislation now being hammered out by House and Senate conferees. C-SPAN, as always, will provide live gavel-to-gavel coverage of the House proceedings. That's a look at what's ahead on C-SPAN. Thank you for watching. Up next, we continue our coverage of this oversight hearing held by the Senate Select Committee on Intelligence, chaired by David Boren of Oklahoma.
A 5-minute rule on rounds of questions as we begin the testimony of the next witness, Mr. Clifford. Mr. Clifford, we would welcome you to the witness table at this time. Sure. And we will, after the introductory statement of Mr. Clifford, recognize members, and we'll have 5-minute rounds of questions, and we'll repeat those 5-minute rounds, but we are going to try to stay with that in an effort to keep the hearing on some reasonable schedule. Mr. Clifford, we would welcome you at this time to join us, and we could have our guests not engage in conversation, please. Let me say that we're especially privileged to have you with us this morning. We appreciate your taking time to be with us. The experience which you bring to our deliberations is very valuable to us indeed, as your background of service as Secretary of Defense in the Johnson administration, a key advisor to several presidents of the United States, and also, of course, as a staff counsel to President Truman during the period of time that the National Security Act of 1947, which led to the creation of the system of the National Security Council and the Central Intelligence Agency as we now know it, were initially created. I think one of the shortcomings that we have in Congress all too often is attempting to legislate in a vacuum. It's a problem that afflicts all of our institutions of government, that we don't often enough reflect on the perspective that experience and the history of organizations and their evolution could give us as we legislate. And I think that the perspective which you bring to us this morning is especially valuable to us, especially appreciated by the members of this committee. And we would welcome your opening statement, any remarks that you might like to make at this time.
Thank you. Did I understand the chairman to say that he was arranging for a 5-minute recess?
No, I was no limitation upon you. That I was indicating to the members of the committee that when they start to ask questions of you, I was going to recognize them for 5 minutes each in rotation. But we want you to please feel free to share your thoughts with us, and with no restriction on time. We just appreciate you being here, and we would value your insights and thoughts very, very much.
Thank you, Mr. Chairman. I have a short statement, and with your permission, I will read it. For I have deep convictions on the subject. It's a subject with which some of us have treated for over 40 years, and this particular emergency now brings into focus the need for attention that this committee is giving to this subject. I am pleased to appear before you today to offer my view on the subject of covert activities, and in particular your current events, to improve the procedures by which such activities are approved by the President and made known to the Congress. This is a subject of great significance to our nation's foreign policy and our system of government. It is also, as we've recently seen, a subject of serious potential abuse. Therefore, the efforts of the committee are most timely and vital. In the last year or so, we have witnessed the recurrence of an all too frequent problem: covert activities that get out of control, embarrass the nation, and undermine our credibility and our capability to exercise world leadership. Moreover, this problem is getting worse. The costs are getting higher, and the damage is getting greater. For this reason, I say that unless we can control covert activities once and for all, we may wish to abandon them. While pleased to be with you today, I must confess to some frustration, not at the committee's efforts, but at the recurring need for such efforts. I can recall some 12 years ago testifying before the Select Committee to study governmental operations with respect to intelligence activities, the Church Committee, regarding the gross abuses in covert activities that were the concern of that committee. In my testimony in 1975, that's 12 years ago, I said, the lack of proper controls has resulted in a freewheeling course of conduct on the part of persons within the intelligence community that has led to spectacular failures and much unfortunate publicity. A new approach is obviously needed, for it is unthinkable that we can continue to commit the egregious errors that have caused such consternation to our friends and such delight to our enemies. I could be making that same exact statement today. The Church Committee helped enact the 1980 Intelligence Oversight Act, and this certainly was a step forward. But today we know that was not enough. Sadly, my words from 75 are all too pertinent today. My recollection also goes back 14 years before the Church Committee came into existence. In 1961, after the attempted invasion of Cuba at the Bay of Pigs, President Kennedy reconstituted the Foreign Intelligence Advisory Board, of which I then served for 7 years, in order to study the severe breakdown in intelligence gathering and decision-making that led to that activity, in order to recommend measures to avoid the repetition. It is my opinion that the so-called Iran-Contra affair was more damaging to the nation's credibility and leadership even than the Bay of Pigs incident. Indeed, my recollection goes back 16 years before the Bay of Pigs incident, when President Truman asked me to study the idea of establishing a peacetime intelligence agency. This led to the enactment of the National Security Act in 1947. Since that time, we have seen an egregious deviation from the original conception of how that act was supposed to function. Covert activities have become numerous and widespread, practically constituting a routine component of our total policy. And with these activities have come repeated instances of embarrassing failure, where the goals of the operations themselves were not fulfilled and unforeseen setbacks occurred instead. I believe that on balance, covert activities have harmed this country more than they have helped us. Certainly, efforts to control these activities, to keep them within their intended scope and purpose, have failed. For this reason, the work of this committee is essential. We've reached a point now where we must reassess the very idea of conducting covert activities. If we are to continue with them and gain any benefit from them, we must find a way to keep them consistent with the principles and institutions of the Constitution and our foreign policy. If we determine that this cannot be done, then again I say, we are better off without covert actions entirely than with them out of control. In 1946, those of us assigned the task of drafting the National Security Act were dealing with a new subject. This nation had not had a peacetime intelligence capability and had not regularly conducted covert activities. Soviet aggression in Europe and elsewhere at that time caused sufficient concern to justify new and bold actions. But at the same time, there was concern that our nation not resort to the tactics of our enemies in our effort to resist them. In preparing the National Security Act, we thus proceeded cautiously, sensitive to the experimental and risky nature of the enterprise on which we were embarked. Accordingly, it was decided that the Act should contain a carefully worded, quote, catch-all clause to provide for unforeseen contingencies. Section 102D5 provides that the CIA shall, quote, perform such other functions and duties related to intelligence affecting the national security as the National Security Council may from time to time direct. The other functions that the CIA were to perform were not specified, but we did expect at that time that they would include covert activities. These activities were intended to be separate and distinct from the normal activities of the CIA, and they were intended to be restricted in scope and purpose. The catch-all clause was crafted to contain sufficient limiting language, quote, affecting the national security. As the committee knows, the National Security Act of 1947 and its catch-all clause remain the only statutory authorization for covert activities. Moreover, the legislation that you are considering does not propose to alter that they would include covert activities. These activities were intended to be separate and distinct from the normal activities of the CIA, and they were intended to be restricted in scope and purpose. The catch-all clause was crafted to contain sufficient limiting language, quote, affecting the national security. As the committee knows, the National Security Act of 1947 and its catch-all clause remain the only statutory authorization for covert activities. Moreover, the legislation that you are considering does not propose to alter the limiting language of the catch-all phrase, but rather aims to enforce it better. On this score, it bears emphasizing. It was by the act of Congress that the CIA was established and that it exists today. It was by act of Congress that covert activities were authorized and continue to occur. This is so because our Constitution confers on Congress the power to make the law, and the President is charged with taking care then that the laws are faithfully executed according to the intent of Congress. In my judgment, the Constitution clearly provides to the Congress an important role in foreign policy, and this role includes the process of overseeing covert activities. It is part of the system of checks and balances among the separate branches of government. And we should remember that the oversight process does not give the Congress a veto, but only a voice. Over the last year or so, the cost that covert activities can inflict on our system of government has been clear. Whatever the specific actions or individual responsibility, the sale of arms to Iran and the diversion of profits from those sales to the Contras in Nicaragua caused severe damage to our country and the institution of the presidency. The President's credibility suffered drastically, and with it, the integrity of the nation's foreign policy. One of the principal shortcomings of the Iran-Contra affair was the failure of the President to notify the intelligence committees of the government's activities. The oversight process could have served a significant salutary purpose, giving the President the benefit of the wisdom of those who are not beholden to him, but beholden like him directly to the people, and prepared to speak frankly to him based on their wide, varied experience. Had the President taken advantage of notifying Congress, he and the country may well have avoided tremendous embarrassment and loss of credibility. The Iran-Contra affair presents this committee and the country with a crucial question. Should the laws governing covert activities be changed? To answer this question, we first might examine the attitude of President Reagan. In his letter to this committee of August 7, 1987, the President said that the current laws are adequate and that any changes could occur by executive order. I strongly disagree. In the Iran-Contra affair, the President displayed an attitude that is antithetical to the oversight process. You will recall that the President signed a finding that explicitly instructed the director of the CIA not to notify the Congress of the activity. For 10 months, the director and others involved abided by this instruction. In fact, the President finally notified the Congress only after the activity had become public knowledge. Much later, after the Congress had begun its inquiry, the President, in his letter to this committee, supported the concept of notifying the Intelligence Committee, but insisted upon 2 exceptions. These exceptions would relieve the President of the notification requirement in, quote, cases of extreme emergency and, quote, exceptional circumstances. To permit these 2 exceptions would make any notification requirement meaningless. Further evidence of the administration's attitude is the Justice Department's December '86 memorandum supporting the President's position in delaying notification for 10 months. The memorandum offered the novel theory that the President may determine what is timely notice based on the sensitivity of the covert activity. According to this theory, the President would never have to inform Congress of a particularly sensitive activity. This theory clearly would undermine the Cole's concept of the duty of the President to keep the Congress informed. Moreover, we find that this continues to be the legal theory of the Justice Department. Last week, in testimony before this committee, a department representative made the following statement, and I quote, "There may be instances where the President must be able to initiate, direct, and control extremely sensitive national security activities. We believe this presidential authority is protected by the Constitution, and that by purporting to oblige the President under any and all circumstances to notify Congress of a covert action within a fixed period of time, S-1721 infringes on this constitutional prerogative of the President." Just last week, that opinion came from the Justice Department. In other words, it is the attitude of the administration that whatever laws exist, the President may interpret them as he chooses. This is not the way that I understand our Constitution is supposed to work. The President's attitude must not prevail, in my opinion, or else recent misfortunes might well recur. So my answer to the question confronting us today is that the laws governing the oversight process must be changed. And the changes must be specific, direct, and without exception. I wish to lend my full support to S-1721, the Cohen-Boren bill. This bill meets the need for change that exists in the important area of notification to the Congress. The bill would require the President to sign a written finding setting forth the particulars of a covert activity within 48 hours of approving it. The bill would require the President to provide the Intelligence Committee with the finding within the same period of time. And while the President could limit notification to the so-called Group of 8, he would have to explain why he was doing so. The President would also be required to give notice of any significant changes in any covert activity. Finally, the bill would prohibit findings that were inconsistent with U.S. law or purported to be retroactive. These are all welcome and worthwhile changes in the oversight process. In my view, however, they are not enough. Tightening of the procedures will do some good, but past efforts of the Church Committee and others have demonstrated that we need to do more. In order to be effective, the new legislation should also contain sanctions that would penalize any failure to notify the Congress within the statutory period. Therefore, I would like to propose for the committee's consideration a provision to be added to S-1721 that would automatically terminate and prohibit the expenditure of funds for any covert activity with respect to which the President had failed to follow the oversight process. This provision would go beyond the ban on funding of unauthorized activities in the Cohen-Boren bill because it would require the President within the statutory period to notify the intelligence committees as well as sign a finding. Furthermore, according to my proposal, any government officer or employee who knowingly and willfully violated or conspired to violate the prohibition against the expenditure of funds for such a covert activity would face criminal penalties. In my view, there is no excuse for failure to notify the Congress according to the law, and there should be no exception to the sanction against violating such law. The purpose of this legislation is not to assume good faith, but to ensure good government. For many years, the United States has offered leadership to the world because of its character as a nation and its devotion to freedom and the liberty of man. We have great economic power. We have unparalleled military power. But our standing in the world community rests mainly upon the confidence and trust that other nations have in us. We don't hold the free world together at gunpoint. It is mutual trust that binds us, and the vital element of that trust is our credibility. Unfortunately, our credibility has been grievously damaged this past year in many parts of the world. It is incumbent upon all who are in positions of authority to take the necessary steps toward restoring our former position. This legislation is a splendid move in this direction and will be of vital importance in reducing the possibility of another similar disaster. I thank you.
Thank you very much, Mr. Clifford, for the very thoughtful presentation which you've made to the committee, and I know all the members value the thoughts that you've shared with us. I first want to turn to distinguished chairman of the Finance Committee, who is chairing a part of the conference on reconciliation that is now going on, conference from which I have been absenting myself this morning to be in these hearings, and I didn't worry about absenting myself as long as the distinguished chairman was there to make sure things were done right. So I want to make sure that he can return to those deliberations as quickly as possible, and I know the other members will be agreeable if I call upon Senator Bentsen first for his comments and any questions so that he can return to those deliberations. Senator Bentsen.
I thank the distinguished chairman for his comments. Let me state first that I've known this man for 39 years, and when I first came to the Congress, I don't know of anyone that has had a more continuing, profound influence over such an extended period of time as Clark Clifford has. I see his lovely wife seated back there. Glad to see her here, too. But I'm, as a citizen, most appreciative of his contributions. You made a rather major statement when you said that you thought that perhaps this country had been more damaged by covert actions than it had been benefited in the past. That's a pretty tough statement. I would assume from what you stated, though, that you're not against any covert action so long as it has proper oversight and coordination between the two branches of government. Would you comment on that?
There's a great tendency to confuse ordinary intelligence activities and covert activities. I would estimate, as a guess, that covert activities may constitute 2 or 3% of our intelligence activities, whereas the other intelligence run 97 or 98%. As you look back over the checkered history of covert activities, you run into the Bay of Pigs. Many of you will remember the Bay of Pigs. That was a covert activity that went wrong greatly to the embarrassment of our country. Some of you may remember a series of events that came in under the cognomen of Operation Mongoose. Those were efforts that were made over a period of time to assassinate Castro. And it broke and got into the papers, embarrassed us all over the world. Some of you will remember the embarrassment with reference to our activities in Chile and Mr. Allende. These are all actions that went wrong. I concede that sometimes one of them may go right and you may not know about it. But during the long years of close association with the intelligence community, there are not very many of them that have been worth trying. The danger of embarrassment is such that it must be regulated so carefully. My own attitude is that if a question comes up about a covert activity, unless it's very clear that there's a good chance of bringing it off, that it can be done reasonably promptly, and that it can be done in complete confidentiality, if there's any substantial doubt about it, I say abandon it. We get along very well without this covert field. It's so limited, but so subject to the danger. I think many of you know the degree of embarrassment that our country sustained in this past year and a half. If you have friends abroad, they write, I get letters from them. What in the world has happened to the United States? You take as a public policy that we won't deal with terrorist nations, and all the time you're sending money to Iran to get the return of hostages. I had one letter that said, it looks to me like America has lost its way. And it wasn't an isolated instance like the Bay of Pigs. It went on for 18 months. And I guess it would be going on today had there not been the publishing of this conspiracy in some magazine that was published in Beirut.
Well, I would say, Mr. Clifford, that I think one of the main bones of contention here is what is timeliness, and being informed in a timely manner. And certainly if you examine the debate in 1980 on it, the Congress felt very strongly that they should be informed of such action in a very short period of time. And certainly from my point of view, nothing like what we saw in the delay in the Iran-Contra situation of some 10 months, and a serious question whether we'd have known then if we hadn't had the leak in the publication of the Lebanese periodical. So I strongly support the position of the bill with a short period of time for notification. But let me ask you one on another one that Senator Specter has proposed. He proposes establishing a statutory inspector general for the CIA, imposing a mandatory jail term for government officials who lie to the Congress in the process of the work, intelligence work of the CIA. How do you feel about a statutory inspector general for the CIA?
I would be opposed to that.
Now tell me why.
I think it's not needed. It places another layer in the intelligence community. If you have an inspector general, you have to have a substantial staff if it's to be worth its effort. You appoint an inspector general, it's done by the president, very likely, almost invariably with the consent of the director of Central Intelligence. I don't believe it provides us with the check that we might think that it would. Well, I think that the whole area of intelligence should be guarded as much as possible from routine treatment. That's a routine treatment. The Inspector General performs reasonably well in the Defense Department, not nearly so well as one would hope that he might perform. That's different. In the intelligence community and in the Director of Central Intelligence, I doubt that the benefit would be equal to the additional risk that it results from putting another layer into the intelligence department.
Thank you. I see that my time has expired. Thank you very much, Mr. Chairman.
Thank you very much, Senator Bentsen.
I'll get on back.
Thank you. Let me ask, pursue the, we appreciate your taking the time to come. Let me pursue the question, the last part of Senator Bentsen's question. Senator Specter has also advocated, we've had discussion, in fact, before this committee on this matter, that we should provide a mandatory criminal penalty for willful misstatements by witnesses to congressional committees. So that if we had someone, let's say, from the CIA that came before our committee, willfully gave a misstatement, that there would be a mandatory criminal penalty assessed. It also provides that that witness may change his statement if he finds he's inadvertently made a misstatement or he reflects upon it. There's a sort of cooling off period of 4 or 5 days to let the witness have the right to come back and alter his testimony. How would you feel about that proposal?
I would be opposed to that.
Why would you be opposed?
And the reason I'd be opposed to it is, first, I think that the laws on the statute books on perjury today are adequate. They're far-reaching, they're effective. Second, there is a general attitude in the law against compulsory terms of punishment under our criminal law. That prevents you from giving any consideration to the particular circumstances that exist in any case. Also, I would disagree with the suggestion made in that offering that if a man comes in, perjures himself before the committee, but then has a change of heart within 5 days, that he can come in and completely purge himself of the perjury. I consider that inappropriate under these circumstances. It might be that he would have come in and perjured himself and for 4 days got away with it. And then there might be a piece in the paper suggesting that he might not have told the complete truth. He would hasten before the committee the next morning and purge himself of the offense. I consider it ineffectual and not helpful to us.
What about as a procedure, and you've participated in many, many discussions in your time of government service, both in official capacity and as unofficial advisor. In terms of the candor of discussion, obviously this committee in closed session often has the representatives of the intelligence community before us. We have questions back and forth about our policy, about their intelligence assessments. How do you feel about whether or not those people routinely should be put under oath when they testify before the committee? Do you think that would help in terms of increasing candor, or do you think it might inhibit discussion?
If you're going to deal with individuals in the intelligence community, if for any reason you do not have confidence in them, then I don't believe you ought to take your time in calling them. If you have confidence in them and you get to know them after a while, I would call them, and in the absence of information to the contrary, you're very likely perfectly able to accept what they say. I think that it complicates and retards the process of reporting if you're going to have a requirement that everybody be put under oath. That isn't the way our government works. Our government works supposedly between people of goodwill who are attempting to work toward a common end, that is the welfare of our nation. So I would not surround that with inhibiting factors of that kind.
I appreciate your comment. I couldn't agree with it more strongly. I think you're absolutely right. I have one chance for one last question, since I'm going to impose the 5-minute rule upon myself. Let me ask a hypothetical to be devil's advocate for a minute about our own legislation. The President must notify at the very minimum under this proposal the group of 8, the 4 congressional leaders plus the chairman and vice chairman of the 2 committees within 48 hours. Let's assume that you do have some highly sensitive operation like the Canadian Embassy kind of operation. Let's suppose that the President, for some reason, perhaps he thinks that that particular member of Congress might have such a strong philosophical objection that he would just feel morally compelled to make a public statement about this matter. Or perhaps that member of Congress has a reputation for unintentionally perhaps being too talkative and careless with information. What would you do if you were advising the President of the United States and you had basis for believing that 1 or 2 members out of this group of 8 really might increase the chances of disclosure of some operation like the embassy operation, let's say, where lives might be at stake? How would you advise the President in that situation? How would you deal with it, or should we deal with it legislatively?
In the first place, I would have hoped that when the President gained that opinion of that particular member of the Congress, that he would have taken steps with other members of the committee to have worked out that plan and avoided that particular difficulty, so that when some emergency comes, he would already have taken care of that. I think the President cannot operate very well in the concept of feeling that there are 1 or more members out of the 8 who are likely to leak confidential matters. So I'm assuming that if he learns that, he very likely would cure that situation before the emergency came up. But even if he hasn't cured it, I feel so strongly about this exceedingly narrow line of covert activities, let's call it 2% of our intelligence activities. I believe I could confine my efforts to working out additional intelligence information until I was able to get the word to the group of 8. And maybe I could get it to the group of 8 in such a manner that they would all be together and not be contacted separately, so that there'd be much less likelihood, if they were all notified together, there's the pressure of the other 7 members, that it was not likely to occur that you get a leak under those circumstances. I feel so strongly, my convictions are so deep, that you cannot have exceptions, that I would go ahead and take the chance of something occurring. As soon as you get to exceptions, I think you ruin the validity of the notification process.
I appreciate your comments, and let me say also, I agree with your comment about the kind of peer pressure that can work. We've seen that on this committee as we've endeavored to establish the credibility of this committee as capable of safeguarding sensitive information. The 15 members of this committee have become the enforcers themselves, and there has been very strong peer pressure. The feeling that if we're going to restore the kind of relationship of trust between the institutions that we must have, we ourselves have to demonstrate that kind of integrity in the committee, and the members themselves have been so strong in feeling it that that's the real enforcement mechanism now in this committee. It's the peer feeling that has developed about doing so. Senator Cohen?
Thank you, Mr. Chairman. Mr. Clifford, I apologize to you for quoting your statement in advance, but there were certain segments that I could not resist focusing upon, because I think that it did provide a very, very important insight into what we're discussing. As I look at you, I think of Justice Oliver Wendell Holmes' comment, who said that we look to the past not out of desire but out of necessity. And I think it's important that we look to the past, and someone like yourself who has stood astride of decades of involvement with various administrations. And that's something I think we tend to lose focus of on this committee at this time, is that we are dealing with this administration. If I had to simply rely upon the judgment of those in power now, I would have no difficulty. We have had a very good relationship with Defense Secretary Carlucci and Mr. Powell, General Powell, Director Webster, Howard Baker. These are all individuals that I would feel comfortable in placing total confidence in their judgment. But we're not legislating or considering legislation for simply this administration. We're considering it for future ones as well. And times may change, and people change, and policies can be changed, and NSDD directives can be changed without restriction. So there is a need to look at it from a much broader perspective, and I think that you provide that. I would also add one other thing about covert actions, and appreciating and in fact identifying with what you're saying, is that with respect to a covert activity, the President has made it clear in terms of his attitude, and you talked about the President's attitude. The President made it clear that his attitude toward covert activity is such that he would never authorize the initiation of a covert activity unless he was satisfied that if it were disclosed at some future time, that he or anyone in his administration couldn't stand up behind that covert activity and acknowledge that in fact he initiated it and set it in motion. And indeed that is a very significant either change in attitude or at least clarification of attitude on the President's part. I think it's entirely appropriate that when we undertake covert activity, that if we do run the risk of having it disclosed, that we can stand behind what we were trying to achieve. And the President has stated that publicly on several occasions. Also, with respect to foreign policy, just a word about that. Foreign policy is ordinarily openly debated in the Foreign Relations Committee, the Foreign Affairs Committee, and there's an opportunity to have an expression of conflicting views and philosophies and judgment. And what ultimately comes out of that foreign policy debate is hopefully a distillation of those conflicting views, and which reflect ultimately a majority viewpoint, which is either in support or in opposition of the President of the United States. And there's one thing we've learned over the years, that no foreign policy is going to be successful if it doesn't have the support of a majority a solid majority of the members of Congress, ultimately reflecting a majority of the people of this country. And that's why we have foreign policy that's so openly and vigorously debated. When we go into a covert activity, a covert action, covert policies, then we are engaging in the very antithesis of that free and open exchange of views, thereby providing that distillation of consensus. And if we are going to use covert actions, then it seems to me, at the very least, we can insist that Congress be notified in such a fashion. I would hope that in almost all occasions prior notice, which has been the practice of this administration, the practice has been prior notice, so that we have an opportunity to give the President the benefit of our views, as you so eloquently stated in your paper, that we are not beholden to him. We are beholden to the same public that he himself is beholden to. We give him the benefit of our views prior to the initiation of the action, not after. But recognizing there might be extraordinary circumstances, we are entitled and demand to be notified in a timely fashion. And that doesn't mean 10 months, and it doesn't mean 6 months or 10 days. It means as soon as possible, and we define that within a 48-hour period. And that is the purpose, to make sure that Congress does not lose, we lose our vote perhaps. We don't have a chance to vote on covert action, but we don't want to lose our voice, again, as you so well expressed it. Final comment, Mr. Chairman. Nothing we can do on this committee can prevent future mishaps or misjudgments or abuses. There is no legislative remedy to the mistakes of mankind. And we can't erect any barriers against mistakes or abuses. We can't legislate or weave a web of regulations that will insulate people against the temptation to abuse power in the future or make mistakes. All we can hope to do is to provide greater definition in a process that ensures the opportunity for members of Congress to reflect their viewpoints in a foreign policy objective. And I simply want to thank you, Mr. Clifford, for the very powerful statement you've made today in support of the legislation.
Thank you, sir. Thank you, Senator Cohen. Senator Hecht.
Thank you, Mr. Chairman. It's a pleasure to be before you today. I've read about you for many, many years. I found your statement on covert activities on the bottom of page one, we may wish to abandon them. When the CIA was formed in the late 1940s, it was determined that we had the information to stop at Pearl Harbor, but no one could put it all together. As I mentioned before, we had the luxury of 2 oceans. Now we're in a different world. Let's say hypothetically, we had information about a terrorist group that has an atom bomb. If we dismantle all of our apparatus for covert activities, we cannot move on a moment's notice to get that terrorist. Do you agree on that?
I think that, Senator, if I might say so, I think you're combining ordinary intelligence activities with covert activities. Most of our intelligence activities are conducted clandestinely. They're in secret. We get all the information in together, we examine it, we do a great deal that's going on all the time under the surface. But those are not covert activities. Your suggestion is a correct one. It was President Truman who said that if we'd had one depository in our country for all the evidence we had prior to Pearl Harbor, we could have predicted Pearl Harbor. If we'd had the word from the State Department, from Joe Gru's cables that came in, if we'd had the information from the Commerce Department about the enormous amount of scrap iron that the Japanese were buying, if we'd had other indications about their attitude toward the oil embargo, we would have learned about it. None of that has anything to do with covert activities at all. That's straight intelligence. Covert activities are those instances in which we're conducting some secret and usually political activity with reference to some other country under a basis that in the event the story ultimately should come out, the president and other top officials can deny that they knew anything about it.
How would you classify Afghanistan, our involvement in Afghanistan?
Our involvement in Afghanistan may have started as a covert activity. It didn't last very long as a covert activity. We are now openly, publicly, and enthusiastically sending arms to Afghanistan, and have been for months and months and months, and everybody knows about it. As soon as an activity of that time becomes overt instead of covert, it leaves the old category and no longer comes under that heading.
I fully understand that, but there has to be a beginning, and as you so aptly stated, it began as a covert activity. And it's been a tremendous, tremendous success, because for the first time we have tied down Russia.
But it wasn't a success, Senator, because it was a covert activity. It started as a covert activity. It couldn't have lasted very long because too many people knew about it. The Pakistanis knew about it, the Afghanistans knew about it, and soon it was public. So the covert activity started. I would say to you that during that short period in which we were secretly sending some arms, I would say that was a modified success. It didn't do very much over there, and we still haven't done very much, but at least we made the effort. But after a while, we were making it publicly.
Well, let's talk about Nicaragua, our covert activities in Nicaragua.
Yes, our covert activities in Nicaragua, I think, should be generally condemned. I was deeply embarrassed when I learned that our CIA was engaged in mining the waters off of Nicaragua. I consider that a terrorist activity. It put us into an impossible position with our allies. They had ships in international waters, and those ships would strike our mines that we had used there. When Nicaragua went to the World Court and complained about our activities, we then said we wouldn't be bound by the decision, and the World Court ruled unanimously against us that we had engaged in international lawlessness. That was a deeply embarrassing experience for all of us in this country. So I think that we can go ahead with what we're doing in Nicaragua. If those believe we should be doing it, I think we should not. I don't think our national security is involved in Nicaragua. I think what we ought to be doing in Nicaragua is helping them with their economic problems. I don't believe Nicaragua is a Soviet base. If they moved anything into Nicaragua that we didn't like and that constituted a threat, we could wipe it out in 10 minutes. We are enormously strong. There's nothing in Nicaragua today, in my opinion, that threatens the United States. So the question, again, of these activities, if we were engaging in some covert activities in Nicaragua early in the stage, that has, I think, probably stopped. And we're probably now engaging in open activities. When somebody named Mr. Hassan Fuss or something flew a plane down, that might be considered covert activities. But has it been successful? I don't believe it has.
Let me just take 1 minute and capsule the crux of the philosophy of what we are talking about today. In the past 2 or 3 days, there have been revelations about Nicaragua, Ortega and his brother talking about a 600,000-man militia. Now, these are not agrarian farmers. We have satellite photography of Russia sending arms to Nicaragua. So are we going now to continue with the different philosophies in 1948 when we had the Berlin airlift and refused to go on, the Korean War where we refused to push ahead? Are we going to go into a conflict with an enemy with our hands tied behind us? Are we going to have a different set of standards than our enemy? And I think this is the crux of this whole legislation today. We cannot abide by one set of rules and our enemies abide by another set of rules. And I thoroughly disagree with you on your statement on Nicaragua.
Good. That makes it nice that we have a free country.
Yes, it does.
The point that you're making about Nicaragua is an interesting one, and I look forward sometime to discussing it with you in private. But you will recognize that it does not involve any longer the question of covert activities. Our actions have become overt there. The debate is, should we send arms? Should we send military personnel ultimately? Should we send other kind of aid? So it's moved into the public domain and I think out of the covert field.
Mr. Clifford, if there were any consideration that that was still a covert action, the members who've even mentioned that subject here today would be in violation of the committee rules.
Right.
Senator Warner.
Well, thank you, Mr. Chairman. Mr. Chairman, has our distinguished witness been given the opportunity to introduce the lady who accompanies him today to this hearing? Would you care to do so?
I thank you very much, but Mrs. Clifford, who has worked with me and counseled with me for 56 years, has followed the practice of occasionally coming to interesting matters of this kind, as a result of which I value her opinion very highly, and I know you're all pleased to have her here.
We welcome Mrs. Clifford here today.
Thank you.
And we will not censor that role or relationship as they do in the Soviet Union.
Ms. Clifford, I think on page 6, if I could paraphrase this statement, you need not refer to it. I thought I'd read it again. It really captures the essence of what we're trying to do here today. And you say here, such oversight gives the President of the United States the benefit of the wisdom of those who are not beholden to him, but beholden like him directly to the people of the United States, and who are prepared to speak frankly to him based on their wide, varied experience. And we're dealing, of course, with the essence of the 48-hour rule and the informing of the 8 senior members of both houses. And to me, that's a very laudatory goal. And if I can find a way to support it, I hope to do so. But I have not found that way. So I want to go back and ask you, a man whom I've been privileged to know as a friend for many years, and one who has a corporate knowledge of the executive branch second to none. Given this goal, why have we waited now until 1987 to address it? You started in 40 years ago, with this problem. A series of presidents, indeed both Republican and Democrat, have been faced with this issue, and yet it's been 40 years and we haven't done it. What has transpired to compel us today to take a step as recommended in the bill, which in the judgment of myself and others is a very substantial invasion into this constitutional right of a president to have the conduct of the foreign affairs as his prime responsibility? What has occurred in this intervening period to compel us here today some 40 years later?
We're in an area in our country that is brought about by our system.
I wonder if you could bring the mic just a little forward there, Mr. Clifford, the microphone just a little bit forward to you. There.
Is this better?
Yes, thank
you. If George III were still in control of the country, we wouldn't have this problem.
We'd have others, but anyway.
We'd have other problems, but we wouldn't have this problem because he would make all the decisions. So after our forefathers got pretty tired of that, they said, we're going to construct a new government. And we're going to construct a government of checks and balances. And we're going to construct 3 separate divisions: legislative, executive, and judicial. And each shall constitute a check upon the other. It has worked remarkably well. So that in areas in which the legislature moves, the president, if he chooses, might veto. They then can overrule the veto. But then that becomes the law. Then you go to the judicial branch, and the judicial branch may say unconstitutional. In delicate areas like managing intelligence, sensitive and confidential matters, that emphasizes that narrow line between the executive and the legislative in which They work together in most instances, but then they have a difference of opinion in some instances. And that's been the circumstance for 40 years. Presidents don't want the legislative body to interfere with their discretion in this very delicate field.
And that's been consistent, both Democrat and Republican, because you've known them all well.
Been consistent all since the passage of the National Security Act in 1947. So they've come up, and presidents continue to insist that they should have the right under these emergencies and extraordinary activities to take extraordinary actions. The Congress has said, but look where that has led us. Look at these national embarrassments that we've had come up ever so often. We haven't found the answer. That's the best answer to your question, Senator Warner. We haven't found the answer.
Let me interject.
I have a deep and abiding hope that maybe you men are going to find the answer. Because as I said earlier, I'm saying exactly the same things today to this committee that I said to the Church Committee 12 years ago. And they wanted to solve it, but they didn't, because they weren't willing to go far enough.
Mr. Clifford, in my one remaining minute, it seems to me that the world has changed substantially in these 40 years, and we, fortunately, remain a nation under the rule of law. But we're now confronted with threats from terrorists, individual, organized, and in some cases, state-sponsored by other nations, none of whom observe any rule of law. And yet we're moving towards placing in this bill further tight restrictions on our president under the concept of the rule of law and checks and balances, when the world and the greatest threat to us seems to be moving in the other direction, terrorism.
No, I don't consider what we're doing as placing any improper restriction upon the president. If we're to have a system, Senator, of checks and balances, why do we have this dramatic exception of saying that a president, without any consultation, in a very delicate and important field, can go off entirely on his own? If you read what the Justice Department says, they say the president has that right. I disagree heartily with that. Now, because what we're doing here is we're not interfering improperly. We're saying to the president, when you decide upon a covert activity, come to us within 48 hours. Give it to us in writing as to what it is you're going to do. And it gives us a chance to talk with you about it. You get the combined judgment and wisdom of 8 men. We might want to come visit with you. We could talk it out with you. If we disagree with you, we might convince you not to go down this road. But the important part is that after you men have made your attitude known to the president, he has a right under our system to say, thank you, gentlemen, I disagree with you, and I'm going ahead with it this very minute.
I hear you, and I'll conclude. I think the Iran-Contra thing was a tragedy for this country, and I concur in your observations and those of our 2 distinguished leaders here. But I don't want to see bad facts make bad law in the light of at least 40 years that the system has worked by and well in the best interest of the country. That's my concern.
Senator Specter.
Thank you, Mr. Chairman. Mr. Clifford, I regret that I could not be here for all of your testimony because we're conducting in the Judiciary Committee the hearings as to Judge Kennedy, and I had to be present there. I'd like to question you about a couple of subjects which you've already testified to, as I understand it. On the Inspector General issue, the legislative proposal calling for an independent Inspector General is one which the select committees recommend, and it's in a bill which I have put forward. And I understand that you have testified that you feel it would be an extra layer of bureaucracy without accomplishing a great deal. Before asking you a specific question, would you mind summarizing for me, I know this is repetitive, your objections to the independent Inspector General provision?
It is my feeling that the general institution of Inspector Generals has worked reasonably well. If an Inspector General is to operate effectively, he has to have a staff. It has to be a good staff. It has to be a trained staff. And my first objection is that it does add another layer to the operation. Second, in circumstances of this kind, Senator, where you have the secrecy that exists within the CIA and the proper indisposition to spread that knowledge out among too many others, I'm not comfortable with bringing a whole new group of people in who are not intelligence trained and saying we're going to make them an inspecting operation of the agency. I don't believe that it would function well, and I don't believe it would be effective. In the third place, again, in the intelligence field, because the President would appoint the Inspector General, and I'm assuming that in almost every instance he would be appointed with the advice and consent of the Director of Central Intelligence. I don't believe you're going to get quite the product from that Inspector General that you would suppose that you would.
Yeah. Mr. Clifford, are you aware of the fact that there is an Inspector General now in the CIA? So
yes, and I've not ever noted that anything much came from it.
Well, that's the problem. We saw his work on the Iran-Contra affair, and it was insufficient. There are some 18 Inspectors General now appointed on an independent basis. The legislation which is proposed would give the CIA director the authority to stop an investigation from going forward, but in that event, the information would have to be brought to the oversight committees to see what is going on, so that it is a layer of governmental activity which is in existence at the present time, and the thrust of the legislation is to provide sufficient independence so that if some impropriety is found, the official, the Inspector General, would have the freedom to act without fear of being fired, since he's not subject to removal because of his independent status.
Well, my experience would lead me to believe that it's not likely to prove to be effective. I believe that the oversight of the CIA should rest with this committee. I believe if you want to have a better control, if you want to have better Inspector Generalship, do it from this committee. Don't set up an extra layer within the CIA. For instance, another suggestion is that the General Accounting Office be brought into the picture, and that the General Accounting Office conduct audits of the CIA financial matters. I would also oppose that.
I'm opposed to that too, so we don't have to take any more time. I've only got a very brief period left. Let me move very quickly, and I appreciate your experience, Mr.
I'd say we have set up our own in-house auditing capability. In this committee, we're in the process of doing exactly what you were saying.
The other subject that I'd like to discuss with you very, very briefly, Mr. Clifford, is the suggestion for a mandatory sentence. And I understand that you've already testified that existing laws ought to be enforced, and I quite agree with you. There's a special problem where false information is presented to the Intelligence Committee, which operates in camera secretly, necessarily so, because unlike a public hearing like this one, someone may see it on C-SPAN and make a comment correcting what a witness testifies to if it is a factual matter, and we do not have that opportunity on a secret session. And it is not within our purview at the present time to do anything about the pending matters. That's going to be up to independent counsel to decide what prosecution should be brought under 18 United States Code Section 1001 for false information. But my own thinking is, based on being a prosecutor for some time, that a deterrent has a very profound effect. And it is very difficult to bring enough prosecutions to deal with the problems which exist, and that a mandatory sentence on the books would have a great therapeutic effect, being directed toward very thoughtful and very knowledgeable people. And the bill provides for a 5-day period when the person can recant and avoid any of the implications of the criminal provision. I'm not interested in sending people to jail who testify before this committee. I'm interested in getting the facts so that the committee can perform its function. And when Judge Webster made some comments about the pending legislation, I didn't ask him about it specifically because I knew I'd get a negative answer. But he had made a comment. I learned at least that much. He had made a comment that the mandatory sentence would at least get the attention of the people who testified. And what I'm looking for is to really underscore the seriousness of the falsification before all committees, but especially the Intelligence Committee, to catch their attention and to try to get some deterrence in effect. And I'd be interested in your observations, and I'll now ask you a question. Do you think it would have a deterrent effect on the kind of thoughtful, knowledgeable people who appear before the Intelligence Committee?
I would doubt it, Senator. I think it's a move in the wrong direction. I think that we have a system of laws in this country that are generally applicable. And I believe we get into difficulties if we begin to search out. We're going to have a separate law for these witnesses before this committee and maybe some separate law for some other witnesses for other committees. Well-presented cases under our perjury laws today can be made and are effective. So I'm more comfortable with our having those general laws and bringing indictments or informations under those general laws. The experience with having specific penalties put into the law has been rather unfortunate. If you have a 5-year sentence that is obligatory and someone commits a really quite a minor mistake, that case comes before a jury and there's a minor mistake been made and the jury says, well, gee, we're not going to find that fellow guilty and send him up for 5 years. You lose effective prosecutions under it. I think that's what the bar has found out through the years. So I generally oppose obligatory set terms for punishment. Last, as I had mentioned earlier in your absence, I think it probably unwise to have that 5-day purging period in which one can come in, because I think it possibly permits one to try to get away with a perjured comment, and if anybody learns about it in the next 5 days, he can always come in and purge himself of the improper action. I think in that particular area, Senator, we have sufficient tools to meet the problem.
Thank you very much, Mr. Clifford. Thank you, Mr. Chairman.
Thank you very much, Senator Specter. Again, Mr. Clifford, let me just express our appreciation for your taking the time to come and share with us the benefit of your experience. We appreciate your testimony today. We appreciate the service you've rendered to this country. And let me say that most of all, we appreciate your example of public service, because it challenges all of us to do our best to give back as much as we can possibly give to the broader community and to the national interest. And your example is a very important one to us, and I know I speak for all the committee in expressing that appreciation to you. And thank you very much for being with us today.
You're very kind, Mr. Chairman, and I thank you.
Thank you. Our next witness will be Mr. John McMahon, if he will come forward. Mr. McMahon, of course, is very well known to the members of this committee with over 30 years of service in the Central Intelligence Agency, a professional in that field with a great reputation not only for capability but for integrity as well. Deputy Director of the agency, previously Deputy Director for Operations, and before that Deputy Director for Intelligence. Mr. McMahon, we appreciate very much your taking the time to come back and give us testimony, again, in light of your own experience on this very, very important subject. We're glad to have you back. We have missed having the regular association with you that we had during the time that you were at the agency, and we welcome you to the committee.
Thank you, Mr. Chairman.
We will receive your opening statement at this time if you wish to make it.
Mr. Chairman, I do not have an opening statement. I have responded to the committee of the draft bills that you forward to me in writing, and I think most of my letter can appear in the record, although there's parts of it that I think discretion would suggest be omitted from an unclassified version. I would like to say before the questioning began that I do appear here as an advocate of covert action. I think it is an essential part of our intelligence portfolio, and that this nation needs to have in its lexicon of capabilities the facility for covert action. I believe that covert action has to be a subtle articulation, so to speak, of our foreign policy. And therefore, my appearance here is based on the premise that, yes, indeed, we will have covert action, and that there is an oversight process that governs that. I will not speak to the constitutional issue between president prerogatives and congressional prerogatives. Simply accept that as a given, and I'll be happy to respond to your questions.
Thank you very much, Mr. McMahon. I have one brief question on a related subject, and then I will turn to the other members of the committee. In addition to the procedures for monitoring oversight or providing for oversight, such as the provisions on written findings, on retroactive findings, the 48-hour notice, and the rest, the committee also has under consideration the proposal, as you've heard, questions directed for an independent inspector general to also be provided for the CIA. What is your view of that proposal? Is that a wise proposal or an unwise proposal?
I would not support such a provision, Mr. Chairman. I think that the key to an inspector general's process is to have that an integral and very much a part of the management of the agency. And that can best be effected from within, from people who are experienced and knowledgeable in the intelligence profession, and report to the director. I think that the committee can look to the director to make sure that the CIA is governed according to the regulations and the law, and that the intrusion or the micromanagement into the independent inspector general, I think would cause that inspector to be viewed almost as an adversary within camp.
So you think it would make it more difficult for him to have the access to the information that he would need?
I think there would be great reluctance on the part of agency employees to freely approach an inspector general with what they thought might be a problem.
So if you have the inspector general internally, where it is known that he has the support of the director, what you're really saying is that the committee, in your opinion, must put its faith not in the inspector general but in the director of the agency.
That is correct.
And that the inspector general will be more effective in drawing out any necessary information if it is known internally that he has the backing and support of the director.
The inspector general should function in the image and likeness of the director to impose his policies and make sure that they're carried out within the agency.
Senator Cohen.
Thank you. Mr. McMahon, welcome.
Mr. Vice Chairman.
I'd like to respond, or at least ask you to respond, to the suggestion was made by Senator Warner earlier, saying that he felt that the Iran-Contra affair as such was a bad experience, but he didn't want to see a bad law made in exchange. I want to assure the senator from Virginia I don't intend to have bad law formulated as well. And that what we're seeking to do is to provide some definition which will not only will help the agency and our intelligence capability rather than hurt it.
Mr. Chairman, you recognize nothing personal.
I understand.
I just drawn on the old law school adage, bad facts, bad law. And that, I didn't mean to draw a parallel.
I understand. I just want to assure the senator that that adage doesn't apply here. That's, and Mr. McMahon, let me turn to you directly. What has been your experience in the field of covert actions? Are you aware of any case in which members of the committee have, in fact, disclosed covert activity to the detriment of the agency during your tenure there?
Not to my knowledge, Mr. Chairman, with this committee. When the public heat on Nicaragua began to unfold, there was a great deal of discussion throughout Congress, and there our activities rapidly became exposed. But I found that the committees, both the House and the Senate, have been extremely responsible in how they've handled our intelligence information.
Are you aware of any case in which the administration would be precluded or prevented from notifying Congress within 48 hours in your experience?
None that I'm aware of, Mr. Chairman.
Could you foresee any circumstances? One thing is troubling to me, the notion that's being raised now that there might be circumstances you couldn't notify 8 members of Congress. Covert activity, as I understand it, a great deal of planning, analysis, calculation, weighing of pros and cons goes on before a covert activity is ever even proposed for any president. Isn't that true?
That's correct.
And this is, we're not talking about a matter of ipso facto, I see a problem and I've got to take action today. That's not how covert action is carried out in this country. I would hope not. But rather, they call upon the agency to make an analysis, to monitor the activities, to weigh the risks, to weigh the types of opportunities that would be there, to look at a panoply of assets in terms of how this could possibly be achieved if we were to go forward with the activity, and then to come forward with at least a proposal saying we think we could do the following. Now that takes some planning and some time, and it's not something that the President suddenly has a light bulb turns on and says, I think I'd like a covert action today. Is that not true?
The gestation period for the generation of covert actions have varied over the years, but I think your statement is valid. There is an assessment made not only of the capabilities to carry out what is desired, but also the risks associated with that.
And as I understand the testimony to date, my experience with the present administration, with the exception of the mining of the harbors of Nicaragua, I am not aware, and based upon statements coming from the President and his spokespersons, aware of any other example other than the Iranian affair as such, where there has not been notice given to Congress in advance. Are you?
That's my understanding and my experience, Mr.
So I find it hard to accept the proposition now that we're looking at a 48-hour period, that suddenly there may be circumstances we can't notify Congress, that this would somehow jeopardize our national security interests, and you come forward and I believe you support the 48-hour requirement.
I do. I come from the position that this oversight committee has to be an integral part of our intelligence program, and as such it has to be a partner, particularly since it holds the purse strings as well as the conventional wisdom of our nation. And I also believe very strongly that unless covert action has a bipartisan support, it is eventually doomed for failure. And I would feel very reluctant as an individual to be commissioned not to advise the committee of something and then come back in a week or two and ask the committee to support a program that requires more money and what have you. I think you have to develop a relationship of trust. And I hearken back to Mr. Clifford's comment, is that if there is concern regarding the security of a committee member, then that should be addressed immediately upon his appointment. And I I believe that the Congress itself bears a burden to make sure that the membership of this committee is the kind that won't be either a fast or slow leak.
Thank you. My time is up, Mr. Chairman. Thank you.
Thank you very much, Senator Hecht.
Thank you, Mr. Chairman. Maybe I didn't get it correctly. Do you endorse any of this legislation before us today, and which one, if you do?
Do I endorse this?
Yes,
I would endorse the 48-hour rule or a 72-hour rule or some definite period for advising the committee.
So that one point you endorse?
The others, I would refrain, urge the committee to refrain from anything that approaches upon the revelation of sources, methods, or for that matter, total liaison involvement in a public fashion.
Isn't that basically the law today for the president to advise us? The fact was, there was a mistake made. It wasn't done, but isn't that the law today?
I believe the law gives the president the provision to direct the director of CIA not to advise Congress.
Not to advise Congress?
Yes, on a finding.
Okay, I'll pass over that.
I believe that's where the question of timely fashion is concerned.
I don't want to go into that at this moment, but I have a couple of differences of opinion on that. Secretary Carlucci brought up a very, very important point, which has troubled me too. What about an area commander? You know, the CIA is not the only intelligence apparatus which can do a covert operation. What about a military commander and military intelligence?
I believe the military commander is associated with an action, I won't call it directly a covert action, which would be deceptive to the enemy. I don't view that as a covert action which the Central Intelligence Agency would call out. I do recall that the House Select Committee on Intelligence began to approach this a number of years ago, but never reached a resolution, and we just focused it back away from the Department of Defense, back on the Central Intelligence Agency. I understood the provision of this law to mean that when the President directs a department to carry out a covert action in lieu of what CIA would do or in support of CIA, then that would come under the ground rules of a covert action, quite opposed to an independent theater commander doing actions that might be termed deceptive.
We're dancing around words. How would you define Grenada?
That was an invasion of an island. And there was advice was given to the committees. We were directed to make sure that the committee members were advised before that operation took place. And we so did it. I tracked down senators at midnight to advise them. But that's a military action, not a covert action.
These definitions, I find it very, very difficult, just like clandestine operations and covert operations. I find it very, very difficult to define, and I'm certainly the different ones who are going to be involved would also find it very, very difficult to define. Is one of the reasons that I don't like a lot of legislation that, as I brought out before, ties our hands and allows our enemies to operate any way they wish.
Well, a simple ground rule that I always used, Senator Hecht, was that if it's the collection of intelligence, then it's clandestine. If it's anything else, then it's a covert action.
My time is up. Thank you.
Senator Warner.
Mr. Cohen, glad to see you again. You're one who finished a distinguished career and
thank you, Senator.
Have gone on to another distinguished career, and we're delighted that you've taken the time to voluntarily come back here today and share your views of how many years of experience?
I had 34 and a half years with the Central Intelligence Agency.
And during that period, how many years were devoted to, say, the covert side or portions thereof?
Well, I had 5 years overseas, and then I worked briefly in counterintelligence for about 6 months. And then later in my career, much later, I ran the office that provided technical support to our agent operations, and that was for almost 2 years. And then finally, I was the director of operations for about 3 years.
Were you present this morning when Secretary of Defense Carlucci commented on this legislation?
Yes, I was, Senator.
And did you hear him give his opinion, based again on extensive professional experience in a wide range of government positions, that a proposal of the 48-hour type that we have before us today in the legislation would denigrate the relationships between our nation and other nations in terms of the conduct of covert operations? Do you have a view on that?
I wouldn't associate the conduct with foreign nations in that fashion. I don't think the 48-hour rule bothers them that much. What bothers them is that any association that they have with CIA, whether providing intelligence information to CIA or assisting CIA in a covert action, become public. If we can hold it quietly, then they accept it. And I believe the nations of the world early on were very reluctant at the formation of the oversight committees because they felt that their associations would be exposed and jeopardized. I feel that they have come to appreciate the facts of life, that we will report, but that we will protect their involvement wherever possible.
Well, let me sort of bisect the question. They now presumably have recognized that oversight is going to continue, and we're really today fine-tuning the magnitude of that oversight, and more specifically the time in which Congress, through perhaps 8 leaders, has an opportunity to express their judgment, a valued judgment, on certain proposed or covert operations that have been initiated. Now, given that, supposing we need to acquire from another nation some of their intelligence because our activities are going to take place in a geographic area over which they have specific knowledge, or knowledge perhaps superior to ours, would there be a reluctance, do you think, if they were time sensitive, to share that knowledge if they felt that the President had to, again, share it with a wider range of individuals, say just the 8?
I believe that is correct, Senator, that a number of nations would refrain from supporting us for fear that their association may become public.
Yeah, so then we have to balance the wisdom of this check and balance system of our government and informing the 8 leaders so that their judgment can be brought to bear on this sensitive situation against potential loss of valuable information
or assistance
to assist in that operation.
Yes, sir.
And that's a tough judgment call.
Yes, sir.
Do you see the world changing in such a way over the span of some 30-plus years that you've been in to now justify here in 1987 such a 48-hour rule?
I don't think the world has changed, but the United States has changed. We're a very open nation, and we have our way of life, and I don't think we have even approached to resolving the problem between what is the prerogative of the President, what is the responsibilities and prerogatives of Congress. I would commend to everyone's reading an article in the Foreign Affairs, this winter section of Foreign Affairs, on Foreign Affairs and the Constitution by Louis Henkin, who is a professor at Columbia University. And not being a student of constitutional law, I found this very informative, but I also found myself falling on and off the log as to which side I was on.
Well, I'm going to fall off in 1 minute and I'm going to lose my time. So I guess I want to come to the very precise point. I'm concerned about the expanding role of terrorism. We proudly remain a nation under the rule of law. Those nations have no laws. Some, certainly the organizations, have none. This concerns me as to whether or not we're moving in a direction to tighten up a little bit when so much of our threat is moving in a different direction, where there's absolutely no accountability whatsoever. Do you have any concern about that?
I do have concerns on any encroachment which Congress might have on presidential prerogatives. But in the case of covert action, I think that Congress must play a role as much as the President. And I would like to think that arrangements can be made between this committee and the President which will permit an understanding and appreciation of our covert activities in a timely fashion.
Well, I commend you for your forthright expression of views. I presume that, or could you presume, or how do you answer the question, perhaps your views consistent with, if there is one that's traditional to the profession, how would you think the professional organization would vote on this?
I would like to see covert action advised to this committee within 48 hours or some stipulated time frame that can be agreed between the President and this committee. But don't leave it open-ended. Senator, every time that happens, and fortunately it hasn't happened that much, but the organization that pays the price is the Central Intelligence Agency,
well, that's the point.
not the presidency.
How would they vote on this if they were given the opportunity, in your judgment?
Well, I would have to refer back to Senator Cohen's quotes of Mr. Gates and Director Webster during their confirmation hearing when they thought that 48 hours wasn't a bad idea. If I'm quoting you correctly, Senator, thank you.
All right. I thank the chair for the indulgence.
Thank you very much, Senator Warner. And Mr. McMahon, one last question, Senator.
Just make it very clear, Senator Warner raised two issues with you. One, the involvement of other nations or identification of third countries or parties, and the 48-hour notice. Put it directly, will the 48-hour notice tie our hands or injure our intelligence agency?
I would have to rely on history to say no. My ability to forecast future events is muddled.
But in terms of the 48-hour notice...
If history is any teacher, I don't think 48 hours would be too large an impediment to impose on it.
Thank you.
I gather on this same matter, though, that if we were, you would feel even more comfortable with the provision of 48-hour notice, which you advocate, if we were not require explicitly in the statute that third countries be named if they were participants.
Yes, sir. I don't think you want to name third countries or even approach to discussing sources. That's part of the fiber of an intelligence organization, and if you expose that, you strip them of the ability to provide the confidentiality that our sources and our liaison contacts feel they deserve.
So you would feel we should omit that?
Yes, sir,
that reference in the legislation. I know Senator Cohen has indicated some willingness to do that, and well, again,
just for the record, the author of that article in Foreign Affairs, Louis Henkin, wrote a letter to the committee endorsing the 48-hour notice requirement.
Thank you, sir.
So that he's not off the log on that one.
Well, I think that he comes out very much in favor of that. But yet, if you trespass through the article, you find that indeed, as he quoted Justice Jackson back in 1954, that in addressing the constitutionality between the President and Congress, there is a zone of twilight, often where authorities are concurrent. And as Carlucci said, the resolution of that is beyond my pay grave.
We're looking for concurrent jurisdiction so that we at least have some role and not be relegated to the back of the theater and watch a covert action being played out without having some voice in the script itself.
Indeed.
Thank you again, Mr.
Thank you,
McMahon,
Mr. Chairman,
for joining us, and appreciate your taking the time. And again, we appreciate your outstanding service in the intelligence community of this country. Thank you very much. Our concluding witness this morning will be Mr. Michael Armacost, the Undersecretary of State for Political Affairs. Secretary Armacost, we're very glad to have you with us. We, of course, have been in communication with the Department, had a very kind letter from the Secretary of State expressing his interest in this legislation and his desire to have the views of the Department presented to us, and we certainly value that input from you, from him, and from the Department. We certainly understand with all the responsibilities he is facing and has been overseas briefing our allies in the aftermath of the summit that it's been difficult to arrange his schedule where he could appear in person for us in time for us to conclude these hearings as scheduled so that we can commence our markup session. But we very much appreciate your being present and presenting the views of the Department and the Secretary, and please also convey to him that as this process goes forward, we continue to solicit his thoughts as the proposed legislation evolves through the markup process and on into floor actions. And we welcome you this morning and would receive any statement at this time that you might wish to make.
Thank you very much, Mr. Chairman.
Hold that mic a little closer to the screen.
I appreciate the opportunity to testify on this legislation, and we appreciate also your kind offer to allow the Secretary, if he feels I don't adequately express the views of the Department, to have another shot at it before it goes to the floor. Judge Webster has explained in detail the reasons why the Central Intelligence Agency has reservations about this bill. I think Frank Carlucci spoke this morning and expressed the Defense Department's views. You've already had testimony from Chuck Cooper of the Department of Justice on the constitutional aspects of 1721, and there's no need for me to repeat all of the specific comments that they've made. But I would like to put this legislation in the perspective of a common effort to improve the relationship between Congress and the President on intelligence matters. The question I want to address is whether it will enhance our ability to use covert action and intelligence resources to further our national interests, and whether it will serve the American people. Covert action, in the view of the Department, remains a very critically important tool of U.S. foreign policy. The United States should resort to covert action only when it's essential to advance or protect vital interests. A decision to engage in such activity entails a judgment by the President that the revelation or acknowledgement of U.S. involvement in a particular activity in a foreign country will hinder the successful accomplishment of our foreign policy and security interests. Our most fundamental problem with the bill is the absolute requirement to notify Congress within 48 hours of the adoption of a written finding, combined with the deletion of the references in present law to the constitutional authorities of the executive and legislative branches. This absolute 48-hour requirement may not be reasonable when extremely sensitive operations require extraordinary security in order to protect human life, as in the case of the 1980 Iran rescue mission. As the Justice Department's testified, we believe also that this requirement would infringe upon the President's constitutional authority to conduct foreign policy, including sensitive intelligence operations. It's difficult to be sure to envisage the precise circumstances that might delay notification beyond 48 hours. I think we would all say that such circumstances are certain to be extremely infrequent, yet it would seem inappropriate to infringe on the President's constitutional prerogative to decide how best to carry out the nation's foreign policy in a crisis. Naturally, the President must satisfy himself that the contemplated actions are consistent with U.S. law and policy objectives. He must take into account the need for support from the American people and their representatives in Congress in the event of disclosure. But to tie his hands in advance on how he discharges this obligation seems neither wise policy nor sound constitutional law. In our view, and in the view, as I recall, of the Tower Commission, the existing laws on congressional oversight provide an adequate statutory framework for congressional notification and consultation on new proposals for covert action as well as existing programs. Problems which assuredly arose in the Iran-Contra affair have been addressed by the President. He has implemented new procedures. He has selected new people to exercise central responsibilities in connection with intelligence matters both at the CIA and in the NSC staff. The bill before us takes the approach of imposing by statute a rigid new procedure for oversight and accountability. It does so in a manner that could exacerbate executive legislative frictions rather than encouraging the spirit of cooperation required for effective policy and oversight. I would emphasize the damage that this bill could cause to our ability to enlist the cooperation of foreign governments in intelligence operations or matters. The requirement to identify in findings all foreign countries which might have any possible role in a special activity will increase their fears of disclosure and diminish their confidence in our capacity for discretion. The same is true with respect to the sweeping requirement in the bill to provide any document of any kind requested by Congress without the language in the present law that makes this subject to the constitutional authorities of the two branches and the need to protect sensitive information and sources. We strongly oppose this provision, in part because it implies that Congress could insist on access to sensitive documents that are part of the deliberative process, including documents containing candid advice to the President from members of the Cabinet. Both the Congress and the executive branch have reflected very extensively on the lessons of the Iran-Contra affair. There's no need for us to remind ourselves the absolute need to avoid a repetition of that unfortunate episode. It is, of course, true that the Iran-Contra affair demonstrated a need for better procedures to deal with covert actions. The President has taken forceful steps in this area. I believe the committee has been fully informed of the new and rigorous procedures that have been adopted in the executive branch. These procedures are working well, and I believe they will ensure that all proposed covert actions are reviewed in a careful manner, taking into account the necessity for action, their consistency with our foreign policy objectives and the law, the appropriateness of the means, and the prospects for public understanding and acceptance if the activities are disclosed. The problem we face is not the inadequacies in the law, but the need to restore confidence and trust between Congress and the executive branch in managing these sensitive activities. We don't believe the solution to pass a bill which could rekindle suspicion or provoke confrontation over a constitutional question. We think it's time to allow Judge Webster and the other senior officials who have been charged with implementing these recently revised intelligence procedures the chance to demonstrate that these procedures work. We see this as operating to the mutual advantage of the Congress and the executive branch. We therefore urge the committee not to recommend adoption of the legislation.
Secretary, let me ask, you've raised the question about executive privilege and the possibility that under the legislation the committee might require submission of documents, for example, that would convey private advice given to the President by his own advisors. And I would certainly agree with you that that's not an appropriate matter under a kind of normal circumstance for Congress to be intruding into. That the President, as a matter of executive privilege and prerogative, should have the right to receive on a confidential basis advice, for example, in communications from his own immediate staff. Would it, the current law has a proviso in it which says that provisions are subject to the, I think it says, to the degree consistent with the responsibilities of both the President and the Congress under the Constitution. In your opinion, if we were to have some sort of general proviso, of course the burden would still be upon the President were he to assert any such constitutional privilege to show that it was justifiable. Would that, in your mind, improve the legislation, or would it have no impact on the legislation from your point of view? By the way, before you came, we've already discussed the fact that on the third countries, there's a willingness on the part of many members of the committee, including the principal author, Senator Cohen, to remove the requirement that third countries be named in the findings, for example. Now, if that were removed, and if there was some sort of general constitutional disclaimer, would those changes, in your view, improve the legislation from the point of view of the Department?
I think they would, Senator. I have understood, and I'm not, frankly, up to date on what has occurred in the markup, but it's my understanding from talking to several of those who are present and have followed this very closely that in discussions with the staff, at least these issues that involve third country information relating to third countries, information relating to sources and methods, and the degree to which we'd be subject to requests for information that touched on the deliberative process have been discussed, and possible arrangements have been worked out. But certainly our concern was omitting language in the previous law that protected our view of the constitutional prerogatives of the President was one of the features that we found objectionable, and restoration of such language would improve the bill from our standpoint.
I think there's some confusion about the restoration of the constitutional language. The constitutional language or reference to the President's constitutional power in the existing law only pertains to prior notice. It does not apply to timely notice. And there's some misconception either within the Department or the Department of Justice or within the administration. The only reference to the President's constitutional power applies to prior notification, has nothing to do with timely notice.
I see. Well, I stand corrected. Maybe my lawyer here has an additional comment to make. But as I understood the question, it sounded to me as though that fix would be helpful from our standpoint.
I think the chairman was referring to something else in terms of including reference to third parties or countries in the finding itself, which would be removed under a revised version.
Right.
And what he really meant to ask you, would you then support the bill?
Well, as I said in my testimony, our principal objection is to the 48-hour, absolute 48-hour notification requirement. That, I think, is the core of our problem, and our reservations about it are in part constitutional. I don't have anything to add, or the qualifications to add much to testimony you've received from the Justice Department on that score. I think the arguments are familiar. You know our position. Yeah, there's a practical point which at least I have heard regularly from people in the agency. I just listened to John McMahon's testimony, found it interesting. But there are occasions where operations require immediate action, which could involve people's lives, where a very fast-breaking situation could be impeded by this notification requirement, either because people aren't present and it would be difficult to carry it out practically, or because, in the judgment of the President, to whom the Constitution does confer very special responsibilities in the field of foreign policy, in his judgment, the operations could be compromised by that loss of flexibility. I admit, surely, that in the Iran-Contra affair, the notification was not timely, in my view. But the executive branch has itself created a procedure that would require regular reassessment in any case where an exception to the normal practice of informing you within 48 hours was deemed appropriate.
Mr. Armacost, on the one hand, you cite the Justice Department for its views on constitutionality, and then you express disagreement with the Justice Department because they've indicated that timely notice is whatever the President says it is. In other words, Congress can't proscribe the definition of timely notice because that's in the President's sole prerogative. And so you're expressing
what I'm saying, Senator Cohen, is that the executive branch has established a pattern of reporting these things to you, essentially within 48 hours, but asserts the constitutional right to the flexibility in extraordinarily exceptional cases to withhold that notification for longer because of the sensitivity of the operation, because of the fear of loss of life, and because the President believes that under the Constitution, ultimately, he does possess that authority.
If that's the case, why in the Iranian affair was timely notice in your judgment not given? After all, lives were at stake. 10 months transpired before notice was given. Why would, in your judgment, was timely notice not given because lives were at stake there?
I can't say, Senator, because we were not a part of those deliberations. As you recall from the episode, the Secretary was first informed, the Department was first informed of the finding in November, and therefore any discussions on this issue were not discussions of which we were a part.
I'm trying to inquire in terms of, in your judgment and experience, why do you think that notice should have been given before the 10 months as opposed to the way in which it occurred, if in fact timely notice means giving the President whatever flexibility he decides he needs? And what, in your judgment, was wrong with the way in which that was handled in terms of its notification, if, in fact, the test is lives are at stake?
I wasn't making a detailed comment. I was simply reflecting, I think, a general judgment that in retrospect...
This is all coming out of the Chairman's time. I'll get to my questions in a moment.
I didn't really recognize that I was still asking questions, Mr. Secretary, but let me ask this question. How would you cure the problem that we have now? Now, you've said that in most circumstances you think that notice should be given, could be given within 48 hours. The President said that himself in his letter to us. He said he will notify us in all but the most exceptional situations where he's asserting his constitutional prerogatives within 48 hours. Now, absent legislation, or if you don't like the way we formulated this timely notice factor, the 48-hour notice in this legislation, how would you protect against how would you plug the loophole? If you were writing this legislation yourself with no constraint upon you, how would you close the loophole that obviously now exists in the current law, where timely notice is not defined, totally is open-ended, and where we had a situation where obviously any reasonable definition of timely notice was abused in the Iran-Contra affair? I think that without getting into the argument as to whether or not the President violated any constitutional responsibility, we won't get into that argument. The Natural Justice Department is going to defend the President because they don't want the President accused of violating his constitutional responsibilities. But let's lay that argument aside. Let's just talk about what is a reasonable definition of timely notice. What kind of procedure would you establish if you don't like the 48-hour formulation? How would you protect then against the possibility of extreme abuse, of having another 10-month situation develop, and perhaps a situation, because had that not leaked, we don't know if we'd ever been told. So we might have never known about that operation, the diversion of funds, the generation of funds really essentially generated from the sale of government property to be then used potentially for off-the-shelf operations and maybe in scores of other places around the world. Now, that really does get the policy making of this country and the actions of this country beyond any kind of a process that we view as a constitutional process. People lose all control, no ability to appropriate funds or control operations, and in this case, according to the testimony of the President himself not being informed about the diversion of funds, we are left with no authority under the Constitution of this country. No person elected by or accountable to the people of this country having any knowledge at all about how the sale of their own property, taxpayers' property, was being used to generate funds to conduct other operations. How would you prevent that? How would you plug that loophole?
You know, I think our view, Senator Boren, is that as the Tower Commission concluded, and I believe the congressional committees that have looked into this have also concluded, the problem wasn't the inadequacies of statutes, but was the failure of individuals charged with those responsibilities to observe the law. And we have taken those lessons to heart by going through a very rigorous review ourselves of procedures within the executive branch. I presume Frank Carlucci went through those with you this morning because he played a very central role in the NSC's revision of our procedures. I participated in that, thought it was a very thoughtful and thorough process, which we now, I think, have a very rigorous set of standards through which we put ourselves. And we also accept the fact that in all except the most extraordinary and exceptional circumstance, the reporting would be within 48 hours. That is a general principle to which we subscribe. We simply would like to preserve the flexibility in the extraordinary case for an exception. But we believe the comity between this committee and the committee in the House and those who are responsible for sensitive intelligence operations creates the kind of relationship in which we not only understand the importance of providing timely notice to the committee, but also recognize the importance in virtually all cases of the advice and counsel that we receive from those of you who are elected officials and who are charged with the oversight responsibility.
The problem with the lessons that we learn from these experiences, and I think there's no doubt that we're all, both ends of the avenue, working very, very hard to repair this relationship. I think that there's a real sensitivity to what happens when there's not candor with the oversight process, when that relationship breaks down. So I think, at least for now, there's a real effort being made, but the problem is that these lessons over time seem to fade. And it seems that we have to relearn these lessons every decade or so in this country with this by repeating the same kind of tragic mistakes. Would you support legislating the procedures specified in the National Security Directive, which, by the way, the unclassified version has been entered into the record by Mr. Carlucci today, under which if the president, in essence what the president does in his NSDD is establish a third track. There's prior notice, there's notice after the fact within 48 hours either to the entire committee or in more restricted circumstances to the group of only 8 members. And then there's a third track, that if the constitutional prerogatives are being asserted for reasons of important national interest, that the president will undertake a periodic review with, in essence, the members of the National Security Council as principal national security advisors, the Secretary of State included. I believe it's every 10 days, is that correct?
That's our procedure, yes.
Is that a formulation that you would advocate for possible enactment? Because, again, what worries me is the experience fades into memory, and another president comes into office in a few months from now, and another administration after that. What is to make sure that those procedures are followed and not changed if we do not legislate them?
We obviously accept the procedure since we've enforced it on ourselves. I think I would prefer, Senator, to submit to you an answer in writing just so I don't breach the views of lawyers who are protecting institutions over the longer haul. But I'll be happy to submit a response in the record.
Senator Cohen?
I have a few observations to make and perhaps a couple of questions, Mr. Armacost. You indicated before that covert action is an important tool, and we agree. For the first time in statutory language, we specifically endorse the use of covert action in order to carry out foreign policy objectives. So there's no disagreement between the State Department or the administration on the need for covert activity in certainly limited cases. But I have to disagree with your statement that somehow this legislation infringes upon presidential power. We do not take away 1 foot or yard or inch of presidential power to act. All we are asking for, and I think what we are entitled to, is to be advised of that action. And so there's no stealing of turf here. We're not intruding upon the president's power to act. But simply if he does take action in a fashion which is secret and covert and is inconsistent with our normal processes of open and vigorous debate in public, then at least 8 members of the Congress ought to know about it. And they ought to know about it very soon. I would insist not on a 3-track policy such as that in NSTD, but 2 tracks at best. I would insist upon prior notification on almost all possible conceivable circumstances, except the most remote contingency that I can't conceive of now, would I then say, I'll tell you afterwards, and that should be within a 48-hour period. You indicated before that the procedures were adequate, the statutes are adequate, and the question comes to mind, if they were so adequate, then how did we have what you described as an unfortunate episode in Iran? Was it the people? Was it the director of the Central Intelligence Agency? Was it the Department of Justice? Was it the Secretary of State, the Secretary of Defense? What was inadequate about it if the procedures were sufficient and the laws were sufficient? How did it happen if the procedures were there? And so I think there's a basic inconsistency in that. What we found out is that the procedures were not adequate. The law, to the extent that it's interpreted as giving the president unbridled discretion and notifying Congress, is not adequate. And so I think there's probably a fundamental difference there as to how the incident occurred, because the people were all good people. I mean, there's no one who was acting from malevolence, trying to undermine the government. In that respect, they believed they were following the law. They got written opinions that said, you can do this. So I think there's a basic disagreement whether the procedures were adequate. There are new people, and I think that we have stated over and over again how pleased we are with the changes that have been made and the kind of relationship that we do have. There are new procedures, not entirely acceptable to all of us, but new procedures nonetheless. But you've indicated that by adopting statutory language, we would do damage our capacity to deal with third countries. And I'm curious about that because I read before, and you were not here, so I'll read it again, a letter to Chairman Boren by President Reagan with copies to Congressman Stokes and Hyde, said the following: the Intelligence Committee should be appropriately informed of participation of any government agencies, private parties, or other countries involved in assisting in special activities. So the legislation really was only incorporating what the President himself said ought to be done. And I doubt very much whether the President would send a letter that would, in fact, damage our capacity to deal with third countries. Nonetheless, I've indicated that I'm prepared to be flexible on how to deal with that so that we don't jeopardize that relationship. The final point about why I think it's important that some sort of notification be given as to who we're dealing with under what circumstances. I recall the Secretary of State was quite firm on this issue when the administration had to go elsewhere to seek assistance for the Contras, and this came out during the hearings. There was a review of a list of countries that certain officials went through. And Secretary of State Schultz, when presented with certain countries, X, Y, or Z, or 1, 2, 3, 4, or 5, said, no, those particular countries will demand too much. That was his reaction to it. They will demand too much. Unbeknownst to the Secretary, he didn't know that several of those countries had already been solicited. But the reaction was they would demand too much in return, because we know that whenever there is a quid, there's always a quo somewhere down the line. The Secretary of State knew that. And surely when it came to the country of Brunei, when they finally settled upon the country of Brunei to solicit, and Mr. Abrams went to London to meet with one of the intermediaries, what was the first question? The question that Mr. Abrams asked, Secretary Abrams asked, will you provide some money for the Contras? And what did the representative from Brunei say? What's in it for us? What's in it for us? I think that whenever we do depend upon third countries, be it financial, be it military, personnel, whatever, somebody in this body has a right to know that commitments are being made in our name, in our country's name, and we should have a voice, or at least be able to express concerns or disagreements, or even indeed support. And one of the ironies of all of this is that this administration has had more support from Congress than perhaps anyone would come to believe. Almost every action has been approved in the sense that we've listened to it, we've disagreed with some, but for the most part, the administration has had great success in dealing with this Congress. The only time that I'm aware of, other than the mining of the harbors, the only time that I'm aware that the President felt he couldn't come to 8 members of Congress was in the Iranian affair. And that was, in my judgment, because of 2 things. Number one, it totally contradicted the public policy for which Secretary Schultz was embarrassed about. He was in Europe promoting Operation Staunch while we were covertly or privately, clandestinely, promoting a different private policy. And secondly, that there was such deep division within the administration itself. Secretary of Defense and Secretary of State Schultz adamantly opposed to the concept itself. I think that was the reason that Congress is not notified, not because lives were at stake. We know lives are at stake. They're at stake in most covert actions, but because the administration knew that the policy would be controversial and the President would hear perhaps advice he didn't want to receive. That was the reason. So I think that I take it all. I have enormous respect for you and for Secretary Schultz, obviously, but you have worked closely with us. We've always treasured your particular advice and insights, and will continue to do so. But there is a rather strong disagreement about the role that Congress has to play, not to trespass upon the powers of the President, but to be apprised when the President is taking action which is outside the normal, open processes that we cherish. Thank you, Mr. Chairman.
If I might just comment, Senator Cohen, when I said that we felt no legislation was required, I was really citing not simply a judgment of the executive branch, but what we've taken to be the conclusions of the Tower Commission, which looked into this rather thoroughly and had a very distinguished former senator among the commissioners, and what we've seen as part of the conclusions in the congressional investigation of the whole matter. Not that there were not mistakes that didn't need correction, but questions as to whether additional laws would have avoided the problem, simply because in this case clearly there were people who didn't fully observe the law that existed.
The Tower Board only looked at a part of the entire investigation. They had limited access, limited time, did not have as much information as the Iran-Contra committee had, and I'd point out that several key members of the Iran-Contra committee, including Chairman Inouye, Vice Chairman Rudman, Senator Mitchell and others have concluded that a 48-hour requirement is indeed desirable.
Well, I again want to express my appreciation to you for appearing, and also ask that you convey again to the Secretary our desire to have his views. As I've said to several members of the administration, it appears to me that there's a very strong likelihood of legislation, and we want that legislation very sincerely to be as good as it can possibly be. And I think the more input that we can receive from the administration as we go through the process, even if the administration should decide ultimately, for reasons of constitutional philosophy, that it would resist final enactment of legislation, I think it's imperative that we do keep this communication open so that the legislative product can be as good as it possibly can be. And hopefully in that process, we may find ourselves more in agreement than disagreement by the time it is all over, because while I agree that as much as anything else, it was a failure to follow process that was already in place. I've stated many times there were memoranda of understanding between this committee, for example, and the CIA, clear understandings between the executive branch, procedures within the executive branch for review of policy, as you've mentioned, just have been put in place now, that were in place then that simply were not followed. So a good part of repairing the damage that has been done is to make sure that all of us carefully follow the appropriate processes that are in place, and that our communication and our oversight responsibility here be systematic, and that there be systematic communication between the two branches of government. And I think that we've gone a long, long way, and I would want the record to reflect this, in improving that relationship. I do think at this point in time, between those individuals, the Secretary of State, Secretary of Defense, General Powell, the Chief of Staff of the White House, the President himself, I think that there is a relationship of trust on both sides. That's been communicated to me. Judge Webster, I would include him in that. It's communicated back to this committee that he has great confidence in this committee and the way in which we are safeguarding confidential information and communications. And we likewise have that kind of confidence in those individuals with whom we are now dealing. We're getting the information we need. Our questions are being answered in a straightforward way, or we're being told they can't be answered, and then we resolve those matters. We've been able to resolve communications successfully. So great progress is being made. But I like to think that if we can further improve the processes, including some statutory enactment that would be binding on later administrations, and do it in a way that will not do damage to the President's constitutional responsibilities, that will contribute to this relationship, so that we have ground rules that are clear to everyone, that we not have ambiguities in the statute. And I think if we do this the right way, hopefully can make a positive contribution to build on the process.
Watching an oversight hearing held by the Senate Select Committee on Intelligence, which is chaired by David Boren of Oklahoma. To contact that panel, you may write to 211 Hart Office Building, Washington, D.C., 20510.
C-SPAN is the cable television industry's public affairs network. Since 1979, C-SPAN has provided nationwide